necessarily rewriting.
Right.
Lord, second proposition which I must mention here at this stage itself. Lord, would your lordships, I'm posing a question to myself, would your lordships read a particular enactment in such a fashion that it applies in a particular manner to one class, that is heterosexuals, and in a different manner to different class, namely homosexual, I say same sex, the broad category, my lord, we have identified. My lord, that exercise, my lord, may not be a permissive interpretative exercise to create a class within.
Use it. This is what the gesture that I made was. When I'm looking for same sex, I don't wear this. But when I'm looking at heterosexual marriages, I look at it, act like this. So is this two-way or three-way switch possible in interpretation?
Correct. So, my lord, in my respectful submission, the statute cannot be read to mean A for some class and B for some class. And second, my lord, this is my apprehension, and I must, my lord, share at the outset. And kindly, my lord, examine this a little seriously. My lord, why this degrees of prohibited relationship? I'm not on, my lord, reworking or restructuring.
By the way, interestingly, are these degrees of prohibited relationships pretty much the same as that would are they lifted from the Hindu Marriage Act, or where do they come?
Sagotra and Sapinda relationship.
Yeah, Sapinda, absolutely.
They are now codified, my lord. Because, my lord, apropos, my lord, Justice Bhatt's query yesterday, this entire debate.
No itemized elucidation in the
Things also.
Yes.
One is the Sapinda, which is you go to the same ancestor, lineal ancestor, and the male linear and the female linear. That originally Shastrik it was 7 and 5. Now in the Hindu Marriage Act it is 5 and 3.
Correct.
Section 5. That is one part where you're talking of uterine blood, etc., where there is blood relationship. There is non-biological relationship also when you're talking of in-laws. So, relationship by marriage. Even there is proscription on that.
That is also prohibited.
It is also there. And this applies equally to all religions and all castes.
My lord, my worry is different. My lord, at this stage, I am, my lord, flashing it. And kindly, my lord, listen to this concern, my lord, very carefully. My lord, what is the fundamental argument of the petitioner, which I respect the argument, that it is my right to choose my sexual orientation. Choosing a sexual orientation is
not right to choose sexual orientation. They say sexual orientation is given to me.
I'm on Nautage.
I'm entitled to my autonomy by virtue of my sexual orientation.
Correct.
And a recognition that goes
sexual
with it.
orientation is not a matter of choice, but a matter of immutable features.
My lord,
that's the argument. I mean,
there are, my lord, there are two ways, my lord. There are two different schools of thought. One say it is acquirable also. Another say that it is inbuilt in the person when a person is brought. Let's not go into that. I'm slightly on a different point. Lord, freedom of sexual orientation is held to be a fundamental right. Someone is attracted, a man is attracted to man, that is considered to be his privacy issue, and he can enter into that kind of a sexual activity the way he thinks he gets the maximum satisfaction. That's my lord, broadly, my wordings may not be accurate, or my lord may be proper also. That's that Nautaj Johar. Lord, kindly visualize a situation after 5 years down the line, based on this very thing, that from the beginning, I am attracted to those persons who are mentioned in the degrees of prohibited relationship. Incest is not uncommon in the world, and world over, incest is prohibited. That I am attracted to my sister. I get, we are consenting adults. We are entering into activities within the Lord privacy, and we claim our right of autonomy, our right of choice, and our right of doing something in private domain. Based on that very argument, my lord, I'm posing a question to myself. Can someone not challenge this definition itself? Why this restriction? Who are you to decide with whom I have my sexual orientation? It
would
may be, my lord, a little
that would be
far-fetched.
far-fetched. That would be far-fetched.
Lord,
So
we used
it's
to
obviously a
treat,
reasonable restriction. You can't have.
we used to treat even this as far-fetched.
But you know, Mr. Solicitor, sexual orientation or your autonomy as an individual can never be exercised. All aspects of marriage, including the entry into marriage, the prohibited relationships, the grounds on which marriage can be dissolved, these are all subject to regulation by law. So it may be very far-fetched for anybody to even argue before us that that orientation is so absolute that I can therefore commit an act of incest. No court will ever
But suppose
even
polygamous,
countenance it.
polygamous marriage. my lord.
Forget about sanctifying it, even
Somebody can challenge, my lord, the bigamy
But
provision.
polygamous marriage, that's again governed by personal law, right? I mean, on the
I'm not on personal law. I'm saying, my lord, if I say that my choice is polygamy, bigamy, the state has no right to intervene.
Your argument perhaps could be more, I would say, if you're leading up to that, one can understand it. That these are universal rules. I think we can all agree that these are universal rules. Now, as long as they were not codified, they were accepted. And that was the law, that was the norm, that they had a normative effect. Why did the state get into it? The states thought this as a universal norm. Now, therefore, I think if you're building up and saying there is a state interest in this relationship, one can understand. What if you're driving at that this is where the state comes in?
But that's my submission.
I think their position too was conceded that when it comes to age also that there is a state interest. So there is no field which is completely autonomous in that sense.
Correct.
Even within the marriage bond, there are certain interests of the state which are legitimate, let us say.
Lord, that is, Lord, in the second limb of my submission is going to be that state has no business to regulate social personal relationships. It is only in exceptional cases where the state
that would be also very an extreme statement of law. If they have made that statement.
I'm saying something else, Lord. Kindly, Lord, I'll just complete that. State has no business as a proposition to regulate any social personal relationship. That statement your lordships are saying is not it's an absolute statement. But I'm on an extension of that statement that the state can regulate certain relationships if the state feels that it's in legitimate state interest to do so.
But of course,
Lord, therefore, marriage was not a regulated social relationship. But the state, in its legislative policy wisdom, decided that we will regulate and we can regulate only if we recognize. And therefore, under the Hindu Marriage Act or any other marriage act, we recognized and regulated. So therefore, that's a legislative choice made. My Lord, leave it at that. But, my Lord, I again, my Lord, I'm insisting, my Lord, that my apprehension may, I wish it's wrong, but may perhaps not be wrong after, my Lord, few years. When your lordships were hearing Navtej Johar, all these arguments were made. The central government, my Lord, said that we leave it to the wisdom of the court so far as the decriminalization of Section 377 is concerned. But I specifically added in my affidavit that this has nothing to do
with marriage.
Future right of marriage, inheritance,
Absolutely,
etc.
no question about it.
And I'll just read, my Lord, from page 1.
Solicitor, don't even label that. You have said that. No, we accept your point on that.
So, my Lord, a step from step 7 to 8 may lead from 8 to 9. That's what I am just, my Lord, putting a word of caution. I'll, my Lord, further. I'll go further.
7 to 8, where you're saying will lead to 8 to 9, that'll be actually 8 to 15.
We can say,
And none of us are looking at step 8.
Regulate social relationship.
The current scenario, Mr. Mehta, or also in the future. The
Lord,
given is
Lord, the arguments, the way they are read for marriage.
Yes.
And I'm saying this with a sense of responsibility, can be made, whether accepted or not, is one thing,
we need to
for challenging incest prohibition as well.
Mr. Mehta, we don't have to labor the point that the state can regulate even social relationships. Once a relationship between a parent and a child, can the parent say, I have absolute control over my child? No, the state says you have to send your child to school.
I leave it at that.
There's an obligation to make sure that your child goes to primary school. That's a relationship between a parent and a child, but we are all subject to the fact that you have to send your children to school. You have to get your children vaccinated. So these are obviously there.
Now coming back, my lord, to that, your lordships would be required to rewrite. Coming back to the main thing.
Let's go and
See, my lord,
yeah.
full blood, definition of full blood and half blood. Your lordships have read, my lord, as hypothetically as requested by them, man, woman, different categories of prohibitions, but your lordship said both prohibitions would apply, and your lordships would bear in mind the petitioners do not represent everyone who is in this particular class. Somebody may say that, no, I don't agree. Why should it apply to both of us? So it would be a risky thing to do. But now full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor by the same wife.
Hindu marriage act. इसी में है ना? Oh, thanks.
Special marriage act.
नहीं, इसमें नहीं.
You're reading from Hindu Marriage Act or
It's a special marriage.
Special marriage.
Act.
Special marriage act. Two
Explanation two.
explanation.
Yeah.
That's right.
Yes.
Full blood and half blood. Two persons are said to be related to each other by full blood when they are descended from a common ancestor, that is male, because the next word is by the same wife, and by half blood when they are descended from a common ancestor but by different wives. We can never reconcile this provision because it says biologically one man has given birth to a child through a biological woman. That's what they say. Number two, Lord, marriage between lesbians. This provision will be redundant because she can't have, Lord, full blood. Even if, Lord, there is a child from artificial insemination, it would not be a full blood child. So merely changing man and woman into persons will make many provisions not reconcilable at all. And, my lord, this full blood, etc., will have an inevitable impact on the succession. I'll show. Yeah, my lord, your ladyship's mic is not working.
Actually, then you also see the Hindu Marriage Act, which section 3G. Huh?
Yes. And your lordship may for the time being take it from me that Hindu Marriage Act will apply. I'll show how it applies, even to Special Marriage Act.
Section 3G.
3G. Degrees of prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is
Absolutely.
a lineal descendant, ascendant of the other. I'm sorry. My lord.
3D. You're talking
2G, 3G.
3G.
Degrees of prohibited, does your lordship get one?
Yes.
Prohibited relationship. Two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, or if one was the wife or husband of a lineal ascendant or descendant of the other, or if one was the wife of the brother or of father's or mother's brother or of grandfather's or grandmother's brother of the other, if the two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or two sisters. For the purpose of...
They cut out the schedule bit.
There's no schedule.
Because they improved on it, and I think they worked out the relationship. If you look at this, I think the Special Marriage Act is the template upon which this was built.
Your lordships are right. So for them, my lord, for Special Marriage Act, there is a separate schedule. Here it is statutorily incorporated in the definition.
Definition would incorporate everything there.
Another, my lord, interesting thing, my lord, explanation 3, relationship by adoption as well as by blood. Nothing may perhaps done on this, but this is another distinction.
And then they brought in the Sapinda relationship in 3F of the...
Yes.
And incorporated the prohibition in 4.4 and 4.5. So this is, SMA is a little more elaborate because it then lists out categories which are absolutely within the,
Yes.
they don't leave it to because obviously SMA is religion neutral. Therefore, they itemize the relationships.
But borrowing the concepts from Hindu law,
Actually the same.
borrowing concepts from Hindu
Borrows
law,
it from the Hindu law.
because this Sapinda and Sagotra is essentially, my lord, concepts of Hindu law.
Yes.
But in some communities, there is a custom which permits that. And that is also
That is excluded, huh? There's an
Section
exception.
4 actually says that, proviso.
Yes, my lord, therefore they
interesting
take
part.
care of that as well.
Actually, anticipating that was brought in only in 63.
Yeah.
63.
Which
But
meant that
by way
for
of an
10
amendment.
years, for 10 years, this prohibition continued.
Yes.
So, for instance,
and,
mama, some communities are mama,
niece,
niece,
Mama
you get
and
it, niece also.
even cousin.
Cousin,
Mama,
sister's daughter.
sister's daughter.
Mama's Banji and son can get married. My lord, possibly, my lord, I inquired.
That is
my
still
lord,
protected because the custom protects.
custom and the custom, the origin, nothing to do with this matter. The origin of the custom was that earlier the daughter-in-law used to be troubled in the household of the husband. So if mama is the father-in-law
Yes.
or fufi is the mother-in-law, then she would be like a child only. That was the reason why, my lord, this custom
There
came.
were many sociological
There are sociological good reasons, my lord.
Land is another issue.
land
Mostly
probably.
land is the issue.
Keeping the property.
Yeah, land is other issue.
Land of the
Bifurcation.
My lord, now kindly see 4C. And my lord, read the way they want to read it. It would be as absurd as, my lord, I would sound while reading this, my lord. Please see C. This is a compulsory precondition of a valid marriage under the Special Marriage Act. The male has completed the age of 21 years and the female the age of 18 years. Now we read person. The person has completed the age of 21 years and the person has completed the age of 18 years. It doesn't make any sense unless your lordships rewrites that for same male sex 21 years, same female sex, but then again, my lord, it doesn't take care of other my lord, categories like transgenders, others, my lord, who are not either male or female. So then kindly see proviso, provided that where a custom governing at least one of the parties permits of a marriage between them, such marriage may be solemnized, notwithstanding that they are within the degrees of prohibited relationship. Your lordship, my lord, kindly leave that and kindly come to, my lord, now section 11. Section 11. I am showing, my lord, the heart and soul, the basic infrastructure of architecture of Special Marriage Act is between a conventional biological man and a conventional biological female. Lord, section 11, declaration by parties and witnesses. Your lordship gets, my lord?
7.
11. Section 11, my lord.
When you go to the third schedule, right? Declaration.
Yeah, I'm sorry, my lord, my learned friend is right, my lord, my learned senior is right. My lord, please see section 4(2). 4(2). Though capable of, this is again a condition, precondition of a valid marriage. Though, B2, your lordship gets, my lord? Though the capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of children. But procreation word used statutorily necessarily mean a union between man and woman.
That may or may not be, in the sense, I'll tell you why, that the emphasis in that provision is not on procreation as much as on mental illness.
Correct, my lord. But
Lack of mental
mere mental...
We're getting the drift of your argument, but this point, this particular provision may be a little different actually.
But my lord, mere unsoundness of mind may not be enough. If one of them is...
I'll tell you why, solicitor. In the case of a heterosexual couple, the fact that one of the spouses cannot procreate does not render that an invalid marriage. Suppose the girl
No,
In a
that-
heterosexual
that's correct.
marriage, suppose she has had a hysterectomy when she was a child, she can still have a valid marriage.
Correct. I take it.
See?
Lord, please come to 11, section 11. And I think my Lord Justice Bhatt saw the form also, my Lord. I wanted to show that form, my Lord. Section 11, declaration by parties and witnesses. Before the marriage is solemnized, the parties and 3 witnesses shall, in the presence of the marriage officer, sign a declaration in the form specified in 3rd schedule. Please see, my Lord, 3rd schedule. Lord, if we have the same book, it's at page 26.
Yes, yes.
This declaration is to be found, is to be filed.
You're referring to clause 3, not related?
No, my Lord, I'm on the title itself and clause 3 as well. Declaration to be made by the bridegroom and declaration to be made by the bride. The act is not gender neutral. And 3, as your ladyship rightly says, I am not related to CD, the bride, within the degrees of prohibited relationship. So bride's mother is not my relative, etc. Lord, just when your lordships are there, see the 2nd schedule also. Just above the 3rd schedule. The notice of intended marriage. I'm not on the legality of notice, but I'm just showing the gender issue. Your lordships gets scheduled, 2nd schedule. It says unmarried, widower or divorcee. And for the bride, unmarried, widow or divorcee. So not only your lordships will have to rewrite the act, your lordships will have to recast even the forms, statutory forms.
Mr. Mehta, that's in para 1 also of the 3rd schedule. What you're reading in the 2nd schedule is in para 1 of the 3rd schedule as well.
Yes, your
Yeah,
ladyship.
you're right. वो वही आ जाता है.
Widower or divorcee or your ladyship.
Right.
Right.
Description of the party.
Yeah. Which is the next provision, Mr.
Yes. Now, your lordships may come to 19. Lord, I forgot to show, my Lord, during the constitution, this parliamentary debates, one of the debate why, my Lord, this act was enacted was that earlier, the previous Special Marriage Act required me to denounce my religion.
Renounce the man.
Yes, denounce my, on if I get married, my Lord, under this act. And that was working as a deterrent. And therefore, 19 continued, but thereafter it was taken away under 21A. That's the distinction, and that's why, my Lord, I say that personal law gets re-entry through 21A. Please see 19. Effect of marriage on member of undivided family. The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religion shall be deemed to effect is a severance from such laws. No, 2 things.
Just read also, sir, 21, before we read 20.
Only kindly pause here for a minute. 19 says that persons belonging to Hindu, Buddhist, Sikhs, and Jain will renounce. They would not be a part of Hindu family, but Muslim personal law continues to apply, Parsi personal law continues to apply, Christian personal law continues to apply, except in succession, which is 21.
That's right.
Yes.
Now below 20. 20 may perhaps not have much relevance. I'll just read it. Right and disability is not affected by act. Subject to provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to same disabilities in regard to the right of succession to any property as a person to whom caste disabilities removal act applies. The caste, my lord, were recognized earlier and that there were certain disabilities which were removed. So, my lord, that rightly, my lord, in the present context, my lord, may not have much relevance. Please see, my lord, 21, where Succession Act is made applicable, Indian Succession Act, across religion, but not other personal laws of Muslims, Parsis, etc. And Christians, my lord. Not, I'm on 21, my lord,
Yes.
Chief Justice, my lord, wanted. Notwithstanding any restrictions contained in the Indian Succession Act with respect to its application to members of certain communities, there are chapters applicable to Parsis, Christians, etc. Notwithstanding that, succession to the property of any person whose marriage is solemnized under this act and to the property of the issue of such marriage shall be regulated by the provisions of the said act, and for the purpose of this act shall have effect as if chapter 3 of part 5 special rules for part C intestate has been omitted. So, my lord, Muslims continue to govern by their personal laws,
Yes.
except in case of succession. Now, my lords, personal laws even for Hindus, which were taken away in 19, comes back in 21 because they found that this is deterrent.
Personal law, no? 21. See, the
We've
thing is for
excluded only
20, 21 years, they realized that this is working
To the it's deterrent.
deterrent.
Deterrent. That I want to marry under special marriage act, but I don't want to renounce
And
Hinduism.
eventually you might be accepted by a family
Yes.
and you are cut out. So therefore,
By law, I am cut out. The society, my family would accept me, and
but law, you're excluded. Therefore,
yes,
therefore they brought it at par. So in that sense, there is equality among all.
correct. So, my lord, where the marriage is 21A, solemnized under this act of any person who professes the Hindu, Buddhist, Sikh, or Jain religion, which a person who professes the Hindu, Buddhist, or Sikh or Jain religion, I have to marry Hindu only. Then only 21 would apply. Section 19 and 21 shall not apply, and so much of section 20 as creates disability shall also not
So,
apply.
Mr. Solicitor, 21A lifts the prohibition or the
19.
disability which is created by 19 only where a person who is a Hindu, Buddhist,
Marries a Hindu.
Sikh marries a Hindu, Sikh.
Yes.
So if you marry outside your own religion,
You're cut out.
you are still cut off from the system.
19. Then 19 applies. Suppose I marry a Muslim, just giving my example.
Yes, you're right.
Then 19 would
You're
govern.
right.
21A would not.
There's one more thing, apropos your submission, to stretch it to a further extent, that 19 provides for severance only in respect of your family status, of the marriage solemnized under this act of any member of an undivided family who possesses these four religions.
I lose coparcenary rights.
Right.
Joint
But
family,
there's one very important thing. So you lose your coparcenary rights. In respect of all other aspects, you are still governed by your personal law.
My personal law. Yes.
So despite 19 having said you lose your severance, there'll be a severance from the status of a family, 19 still holds intact the applicability of all other aspects of your personal law.
Correct, my lord. I'm obliged, my lord. That's the submission, my lord. Therefore, my lord, I have been respectfully urging that it may not be a choice while examining Special Marriage Act not to touch personal laws.
It's intricately interwoven with.
It is
The
interwoven.
moment you get into 21A even, or even 19, succession is governed by the Hindu law, whatever it is. If it is Hindu, Hindu law. If it is someone else there, that concerned personal law, willy-nilly creeps in.
Yes, my lord.
So section 21(1)(a) is like that wormhole into which everything comes in.
Lord, in fact, this is a comprehensive exercise. Apropos your lordship's query yesterday, we checked up that from 52 to 54, 50 to 54, Lord, the entire debate was Hindu Code Bill, and this was a part of that very Code Bill.
And then they finally they bifurcated it
Thereby, yes,
into three parts.
into three parts. My lord, for Hindus uncodified became codified, and for others, Special Marriage Act came. And my lord, there is an interweaving of, my lord, the provisions, my lord, interweaving, my lord, I'm sorry.
As they say now, there's some kind of a cognateness to these enactments.
Yes. So
Cognate.
they are all, my lord, intertwined. My lord, I'll just read, my lord. My lord, I'll give the my lord, a report, Law Commission's report, which we could find out
Yes.
yesterday.
Yes.
When 21A was introduced. My lord, I'll
This is interesting.
place the copy, my lord. It is in 59th report of Law Commission of India, but they quote the select committee recommendation when 21A came to be introduced.
Do we have that in a compilation?
Is it there in volume 1?
My lord, it's not there. I'll just check, my lord, because we yesterday, my lord, tried and find out. I'll give the
It's the 59th report, huh?
59th Law
59.
Commission report.
Select committee.
No, my lord, Law Commission's report, which quotes select committee.
Says he has not filed.
इसमें मिलेगा. It's Justice Gajendra Khatkar's report, huh?
Yes, my lord. No, it's not there, my lord. I'll, my lord, place it within 10 minutes.
All right.
Allow me to
Just
read.
read it.
In the documents folder.
Volume 10.
Mr. Solicitor, just read it out. It will be a short one paragraph.
There is one paragraph, my lord.
Just read it, that's all.
Why 21A was brought in. It may not be necessary to shuffle through, my lord. I'll just read, my lord. In our opinion, that the select committee says, in our opinion, it is desirable to exclude from the scope of this section cases where both the parties are Hindus. In such cases, the law of succession, otherwise applicable, should continue to apply. We see no reason why the fact that the parties choose to marry under the Special Marriage Act should make a difference in such cases, i.e., where both are Hindus. We recommend that such cases should be excluded from Section 21.
Oh, I see.
Yes. Lord, the reason was, Lord, registration of a marriage has never been compulsory. Even today, it is not compulsory. It's a personal choice, whether it is under the Special Marriage Act or under the Hindu Marriage Act or under any other marriage act.
Registration, but it does not make it valid if you don't register. Correct me, I think it is compulsory, but failure to register does not render the marriage void or an irregularity.
Compulsory.
Maybe, you know, it depends. But
Hindu Marriage Act, it's not compulsory.
Compulsory, is it not?
It's not.
And what
but
is
my lord,
Special Marriage Act?
the deterrence was,
Yeah, that is meant for registration.
Lord, there were many marriages in those days when this 21A came, which were solemnized.
You can inquire from across the people in the court, how many have marriages.
My learned senior says his marriage is not registered.
Same here. Same here.
Where is the proof, Mr. Dwivedi? Where is the proof?
He'll raise our hands.
No, we
If I'm not wrong, I think this compulsory requirement of registration of marriage was introduced a few years back when they said
Recently.
even if you are married according to Hindu law or any other thing, you must
yes.
register your
My
marriage.
lord, earlier what used to happen, the marriage would be, my lord, solemnized as per Hindu rites, Saptapadi, etc., not under Special Marriage Act. But I want a certificate of marriage. So, therefore, my lord, it became a deterrent that if I take certificate, I'll not be governed by Hindu Succession Act.
Right.
I think one state used to, it used to be
State provision,
compulsory.
there is no
You know,
national.
There is in
because of
Tamil Nadu.
8.2, because of section 8.2,
Yeah.
8.1 says the rules may be made, but 8.2 says that the state may make it compulsory.
Yes.
But it also says that if you breach it, it will be only punishable with 25 rupees.
Yeah,
It does not affect the validity of the marriage.
Correct.
80% of marriages in the villages, they're not registered at all.
Absolutely, you're right.
Tamil Nadu, I think, made it compulsory.
It is socially.
If I'm not wrong, Mr. Datar, I think
Relatives collect. and then
Absolutely.
it's known.
Ordinarily.
Tamil
Mr.
Nadu, it became compulsory
But
because
then-
of that form, no, self-respect marriages. Swayamvadayam. So that was made, I think,
Right.
section 7A or something was enacted.
Otherwise, you have to take evidence of, show your wedding photograph album.
And if you require a visa,
Certificate from the Pandit.
require a marriage certificate.
Only for visa, it will-
Visa, another thing.
marriages could be solved.
My lord, therefore, section 15 came. Section 15, my lord, is registration of marriage is solemnized under other laws. You can still get a registration, which may not be governed by
15 of the
registration.
Hindu Marriage Act.
No, my lord, Special Marriage Act, section 15.
That is, of course, there.
Your lordship has section 15.
Yes.
Yes.
Any marriage celebrated, whether before or after the commencement of this act, other than a marriage solemnized under the Special Marriage Act or under this act, may be registered under this chapter by a marriage officer in the territories to which this act extends, if the following conditions are set is fulfilled: the husband and wife, etc., etc. So, my lord, if there is a marriage as per Hindu rights, not under Special Marriage Act, I can go and get it registered, my lord, under section 15.
In other words, if notice, the notice mode is accepted, then the registration itself is a marriage ceremony.
Yes.
It's
It's
a-
a marriage certificate. But it
Itself is a marriage
Yeah.
ceremony.
Just go to the and get yourself registered. Yeah. And interestingly, you know, see how well that section is worded. Section 15 says any marriage celebrated.
That's right.
So celebrated
Not
would mean
solemnized.
anything, not solemnized, celebrated. You have celebrated the marriage. You have invited 20 friends,
recently,
you
my
have
lord,
celebrated them.
Datar told me that a week before, the marriage was 2-minute affair, I think. He attended a marriage, my lord, in Chennai.
It's called self-respect marriages.
That's all.
That's all. No other.
And then you can get it registered here.
I think if the Lordship sees, Hindu has some 8A or something section where they have.
7A, I think it used to be there.
Amendment.
The Tamil Nadu amendment, no? Yeah.
I think it's the second shortest, I mean, this,
Yes, 7A, Tamil Nadu.
After section
Swayamvar.
7A.
Yes, but that's a Tamil Nadu amendment, my lord.
That's
Yeah,
in
Swayam
60s, I
Mari
think the
Thai,
first,
Swayam Mari Yathai
I
marriage.
I
That is
think it was
Swayam.
made in the 60s, right?
68.
68. The
after
first government of,
the DMK government.
yes. after the
1967, with effect from 20th January 68.
Even came, my lord.
But Mangalsutra is the same.
Tamil Nadu.
Yes.
Yes.
Lord, please see section 18. Why this was a deterrent and 21A had to be brought in. My marriage is solemnized as per Hindu rights or as per Muslim nikah right, whichever way.
Interestingly, 15 also uses the expression husband and wife.
Husband and wife. Well, there's more than one, my lord. They are husband. For example, my lord, your lordships may see 12. 12 proviso. Last, my lord, last line. Lawful wife or husband. Well, but there's several, my lord. I'm not reading everything because there are several places. My lord, but 18
Their
says.
contention, of course, was wherever it's husband and wife, treat it as spouses or person.
Yes, my lord, that.
But your contention is that that's not enough. You will have to, because there are so many other interlinkages which you can't then.
Then you will have to restructure or redesign.
It's not, according to you, just a question of reading the expression person for husband and wife, or just spouses or for husband and wife.
Yes, my lord. Now, my lord, please come to the divorce. And there is some, my lord, substantial ground on that. Divorce, my lord, section 27. Subject to the provisions of this act, I'll not read everything, my lord, because the contents are not relevant. The purpose is different, my lord. The subject to the provisions of this act and to the rules made thereunder, a petition for divorce may be presented to the district court either by the husband or the wife on the ground that, Lord, these grounds are available to both husband and wife. Correct, my lord? Now come to 1A. I'm not reading the grounds, it's not relevant for the purpose. 1A. A wife may also present a petition for divorce to the district court on the ground that her husband has, since solemnization of the marriage, been guilty of rape, sodomy, or bestiality, that in a suit under section 80 of so-and-so, 125 of CRPC, so-and-so, a decree or order, as the case may be, has been passed against the husband, awarding maintenance to the wife, notwithstanding that she was living apart, and that since passing of such decree or order, cohabitation between the parties has not been resumed. Now, my lord, the answer to this was, by the other side, that let both have both the grounds for divorce. Lord, as I recollect correctly, Lord, when this was pointed out, that there are separate grounds available to both. And 1A applies only to wife. So who will be the wife? In a man-man marriage, in a woman-woman marriage, or in a man transgender or woman transgender marriage, or two transgender marrying, who will be the wife? The answer was that they would both have both the grounds. Now, Lord, there is a problem. And the problem is, can your lordships read a statute which gives one additional ground of divorce to one class to the detriment of heterosexuals, for which the Special Marriage Act is enacted? So there would be a class within the class. If I am heterosexual, I will not get, as a man, the grounds under 1A. Otherwise, wife also can be guilty of rape, bestiality, etc. But if it is a same-sex couple, 27 would apply differently and both would be available, my lord. That would be not, my lord, a correct way of interpreting statute, my lord. Applying one section in one way to one class and differently to the class for which the act is enacted.
Yes, Mr. Solicitor.
Lord, please come to page 31, section 31. Court to which petition should be made. This is again not reconcilable. Section 31. Your lordship gets, my lord?
Yes.
Section 31, my lords. My lord Justice Narasimha gets.
Yes, yes.
Every petition under chapter 5 or chapter 6 shall be presented to the district court within the local limits of whose original jurisdiction marriage was solemnized. The respondent at the time of presentation resides, parties to the marriage last resided together, or please see 3A. In case the wife is the petitioner, where she is residing on the date of presentation of the petitioner. In case of a gay marriage, who will be the wife? In case of a lesbian's marriage, who will be the wife? In case of a transgender marriage, who will be the wife? These questions will arise. And we cannot leave it just that in individual cases, they would be taken care of. Across the country, this would arise. So now kindly come to section 36. Alimony pendant light. Your Lordship gets one? Your Lordship gets one? 36. Yes. Where in any proceedings under chapter 5 or chapter 6, that is judicial separation or divorce, it appears to the district court that the wife has no independent income sufficient for her support and the necessary expenses of the proceedings, it may, on the application of the wife, order the husband to pay to her the expenses of proceeding and weekly or monthly during the proceedings such sum as having regard to husband's income, it may seem to the court to be reasonable. Now, my lord, if your lordships were to read person, applicable to all, then, my lord, right of a non-LGBTQ wife will be taken away, because then husband can also claim alimony from her.
Just come again.
My lord,
but that's happening in heterosexual marriages too, Mr. Mehta. That's we've all come across it at different times in our jurisdictions, where the husband also claims.
But here only wife is given right. Please read it again. From the husband. Lord, may I slightly rephrase this? It says, if the wife establishes that she has no means of income, right, she can apply, and husband is under an obligation to give her maintenance pendant litig. Now, my lord, first of all, there cannot be any decision by the court who is the wife in same-sex relationship. I'm not elaborating, my lord. But if your lordships were to read person instead of husband and wife, correct? So one person will be entitled to claim maintenance from another person, meaning thereby, in case of heterosexual marriages, to which this act applies. In fact, it applies only to them, according to us. A husband can also claim maintenance pendant litig from wife. And heterosexual.
Alternately, if it is interpreted to read as person only in the case of a same-sex marriage, then there will be a distinction between same-sex and heterosexual couples.
That again,
because in the case of a heterosexual couple, the husband cannot claim maintenance under 36. But in the case of a same-sex couple, we would be reading it in such a way that either spouse can claim it from both.
But one of the men can. If he claims that I am the wife.
Depends. Oh, it depends. Yeah.
He says, I am the wife. Or in a lesbian couple, one of them says that I am the wife.
Because one of the arguments made was if you identify yourself with that role.
Orientation.
Orientation, role. Role was the word used. I play the role of a wife. And which court, my lord? How can the court decide what is true?
That will become a preliminary issue.
It would.
That will become a
jurisdictional issue.
It would be. My lord, therefore, and
that's an impossible.
And again, my lord, fundamentally,
that inquiry to say that who
Apropos your ladyship's Lord, remark, your ladyship is right. Under section 24 of the Hindu Marriage Act, that permits both husband and wife to claim
either party to marry.
Yes, my lord.
That's why we've come across in many.
Yeah, lordships come across because 36 of this act restricts only entitlement to wife.
Wife.
In that sense, it was a progressive enactment.
Yes.
It went beyond because it recognized that
It could be a husband.
Any one of the two
could be
spouses
one of
could
the
be
two.
destitute.
Even section 124 CRPC
I was just going to say,
entitles even parents to claim
Yeah.
maintenance. Parents, children, etc.
of those things came because of amendment.
In Muslim law, my lord, it's different again.
For 125, the obligation is straight on his wife, neglects to maintain his wife.
Your
His
lordships are on
legitimate or
125?
illegitimate, 125.
125, my lord, yes.
His legitimate or illegitimate minor child.
His wife, unable
His
to
legitimate or
maintain
illegitimate
herself, or
child. His father or
legitimate
mother.
illegitimate children, his legitimate or illegitimate child, his father, mother, etc.
125 doesn't apply to women.
That's again is
Maintain a
restricted
husband
to.
or
But 24% talks of husband or wife.
Yes. Either way, my lord, if wife is more, my lord, has more means of, my lord, income, etc.,
Strong.
then husband can also, my lord,
That's right.
claim maintenance. Now, my lord, last section, 39A, Special Marriage Act. I am not, my lord, troubling your lordships any further. 39A, enforcement of decrees and orders. All decrees and orders made by the court in proceedings under Chapter 5 or Chapter 6 shall be enforced in the like manner as the decrees and order of the court made in exercise of its original civil jurisdiction for the time being are enforced. Lord, I'll show there are separate provisions in CPC for execution for male and for female. Sixty-one. Lord, now,
Mr. Solicitor, therefore, looking at the conspectus of these provisions, perhaps we can conceptualize your argument by saying that reading the provisions of the Special Marriage Act, and if the court were to make an effort, as the petitioners say, to reinterpret the provisions, there would be three major problems. One, it will involve substantial rewriting of the legislation. Two, it may also involve the court ignoring some provisions which have been introduced as a matter of public policy, as we saw the additional grounds in the case of a woman for divorce. And third, it would involve reinterpretation of personal law, because there are segments of the Special Marriage Act which specifically contain a reference to the personal law. So there is no way in that, the third category, there is no manner in which the court can avoid the interface between the Special Marriage Act and personal law.
And I'll respectfully add the fourth, that court would not read any statute so as to make it applicable to one class differently and another class differently. 715.
Court cannot adopt a dual approach.
Let's
Yes.
check. I didn't follow that.
So our philosophy permits.
Yes, my lords.
Yeah,
And,
right.
and, my lord, there are several questions, my lord. Some of the questions were,
Mehta, just to clarify 39
Everything
once
is one.
more.
Everything is not one. Our philosophy.
Lord, and in with the ingenuity of lawyers and litigants, my lord, it may not be a far-fetched idea, my lord, that a heterosexual couple can come and say that now apply me the provisions which you have read for LGBTQ, because we may be heterosexual, but internally we are not. I feel different way, etc. I don't wish to elaborate any further, but it opens room for several my lord, complications which your lordships cannot conceive right now. So now,
Will you repeat yourself on what you were pointing out in section 39, appeals from decrees and order? What was the point you were making?
Core of our philosophy.
Section 39.
39A, my lord, the decree will be executed as if it is decree of the civil court under civil procedure.
Right.
And I'll show there are separate provisions for male and female under the CPs.
We can't read.
And mail it to Mr. Mail it to the solicitor. Yeah.
Solicitor.
Yes, my lord. Now I'll just quickly, within 10 minutes, 15 minutes, show your lordships, my lord, how other provisions would become unworkable. Quickly, just illustratively. Please come to my first note yesterday file, my lord, page 61.
Just 1 second.
My lord, it is note 1. It's a submission on the question that only legislature can deal with. That's, my lord, the title. Yesterday's note, my lord.
Yesterday's note. Huh?
Note
Page
one.
61, that is 64, PDF 64.
Just 1
65.
second, huh?
Sorry.
PDF 64, note 1.
God, not 1. PDF 65.
You can't get
Yeah, yes.
petitioners.
Lord, now
Para 112,
114.
114.
Next page, brother. Maybe you're ready.
Yes. No, you had read up to 113.
Yeah, yes, ma'am. But 114. I'm not going to read the whole.
What's
I'm
the
just giving
PDF
the
page?
flavor of other provisions, which will be affected, my lord, which are not before your lordships. Now, my lord, Indian Succession Act undisputably applies.
65.
Yes.
My lord, Indian Succession Act undisputably applies to all except Hindus. Hindu would be governed by the Hindu Succession Act. in a given situation if he marries Hindu, otherwise Indian Succession Act. Now, this also, my lord, kindly just one or two sections, just for the flavor. Domicile acquired by woman on marriage. By marriage, a woman acquires the domicile of her husband if she had not the same domicile before. So it will have to be decided who is the woman. Wife's domicile during marriage. A wife's domicile during her marriage follows the domicile of her husband. For passports, etc., this issue would arise and you will have to decide who is the wife. I'm not reading all, but my lord, Succession Act provides for widow, widower, husband, wife, father, mother, etc. Well, just highlighted part also, if you can, lordships can read. 33A. A widow but no lineal descendant and the net value of his property does not exceed the whole of his property shall belong to the widow. Now, my lord, if in this relationship one partner dies, whether he leaves behind a widow or a widower, then, my lord, your lordships may see 43 at the foot. In the intestate's father is dead, but the intestate's mother is living. Now, my lord, next generation. My lord, marriage is permitted, they adopt, and someone dies. And father and mother is, my lord, LGBTQ couple. Who will be treated as dead as father and who will be treated as dead as mother? This would be the, my lord, dilemma and can't be, my lord, foreseen by your lordships. Now, please come to 115 and quickly, my lord, I'll take your lordships through the flavor of, my lord, other 160 sections which will be affected. Though they are not arising here, my lord, for your lordship's consideration. But inevitably they would be affected. They are not in question, they are not for interpretation also. But the moment your lordships reads the word person, in case of man and woman, wife and husband, these are the consequences which will follow. Just, my lord, highlighted part, and I'll read only some sections. I'll skip remaining section. Please see 1. Section 3G, degrees of prohibited relationship. Your lordships have.
Where are you?
Sorry,
Where are you reading?
Lord, I'm sorry. Page 115 of my yesterday's.
Even I was looking at that.
No, I'm sorry, my lord. Page 115. My apologies.
Mr. Solicitor, what PDF page is it?
It was 119, lords.
119, right? Hindu Marriage Act.
Yes.
On the top, right?
You are giving us PDF pages by asking your junior. You are supposed to give us PDF pages by having your own.
No, Lord, I have calculated it is +4. So it's a simple formula.
Mr. Solicitor, I'm putting you on notice. For this matter, fair enough. Now we have exempted you, you know. But we are not going to read down the statute in the next matter. You have to have your iPad open. You're not going to be looking at Kanu and asking him to give you pages next matter.
I am already in.
Get ready and.
I am already.
Otherwise, we'll ask your junior to argue. We'll ask Kanu to argue.
Yes.
Only he who has or she who has an iPad will argue.
Solicitor, see, the Chief Justice has enforced this norm on me, so you can't escape the norm.
No, nobody. Well, I am already under a continuing mandamus and I am already in breach.
And the norm is applicable even at Tughlaq Road, you see, because Justice Kaul is away from the courtroom, and yet he's. I really appreciate that because Justice Kaul picked it up for the first time in this matter, and he's completely.
Yes.
Absolutely felicitous now. Justice Bhatt, of course, has been doing it since Delhi High Court days.
No, Lord, I did one constitution bench, Lord, fully on iPad. Lord, I'll even next time, Lord, in this matter also I'll be on the iPad. Lord. I can, Lord, assure your lordships. Lord, please come to 119. Lord, this is Hindu Marriage Act, which the same parliament, the same legislature, using some word, my lord, in different statute is presumed to know the same meaning. Lord, section 5(3), Roman 3. the bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. Lord, same section 3, bridegroom and bride. Then your lordships may only see, my lord, punishment for bigamy. Or please see, my lord, section 19, item number 8, court to which the petition shall be presented. 3A, in case the wife is the petitioner where she is residing on the date of presentation. Your lordships may, my lord, come next, my lord, page 121, PDF 121. I am skipping rest, my lord. Hindu Adoption and Maintenance Act, my lord, applies to me. I can adopt, my lord, if I have married a Hindu wife. If I marry Hindu wife, my lord, under the Special Marriage Act, Hindu Adoption and Maintenance Act would apply. Section 12, capacity of a male Hindu to take in adoption. And 13 is capacity of a female Hindu to take in adoption. You'll have to necessarily be having different eligibility to adopt a child. Because if it is man, he cannot adopt a girl child less than 21 years of difference. If it is a female, she cannot adopt male child. So it can never become gender neutral. Then, my lord, 15 is maintenance for wife. 16, maintenance of widowed daughter-in-law by the father-in-law. Lord, suppose in a same-sex couple, one of them dies and the other claims against the father-in-law that in our relationship, I was the daughter-in-law. I was the wife and therefore your daughter-in-law. Impossible, my lord, to decide that fact. That is something, my lord, in abstract, no court can decide that. It has to be, my lord, a biological woman or a conventionally known biological woman, my lord. Then dependents are also defined in 17, my lords. A, from the estate of her husband, and B, from her son or daughter, if any, or his or her estate. Then, my lord, Hindu Succession Act. Your lordships have, my lord, indicated already, I am not reading it. If a female Hindu dies without making a will, there is a separate list of succession. Class 1, class 2, agnates, cognates, but class 1, class 2 changes. And this is, my lord, applicable under section 21A of the Special Marriage Act. There is no dispute. If a male Hindu dies intestate, then there is a separate list provided. But there also, if a male Hindu dies intestate, wife is in class 1 heir, widow is in class 1 heir. Whether in case of a same-sex couple, one of them dies, the second can claim as a widow or not. Hindu Succession Act will have to be, my lord, suitably amended. Then natural guardian, my lord, Hindu Minority and Guardianship Act applies because of 21 Act. If both are Muslim, both are Hindus, both married people are Hindus. Kindly see A, the natural guardian of a Hindu minor in respect of the minor's person, as well as in respect of minor's property, excluding his or her undivided interest in the joint property are, in case of a boy or an unmarried girl, the father, and after him, the mother. So you'll have to decide who is the father. There is no difficulty as of now because it is not tried to be made gender neutral. And we know father means a particular attribute, mother means a particular attribute. Similarly, my lord, your lordships can, my lord.
Solicitor,
please, your lordship.
To test it as a devil's advocate,
yes,
can it be said that under all these provisions, the biological sex at birth is what is to be taken into account, as the purpose is only to facilitate a marriage of a gay couple? Can it be said? I'm putting a question to you.
Yes, my answer is this, my lord. First of all, if we go by the intent and purpose of the legislature, the intent and purpose is that the legislature always thought of biological conventional man and biological conventional woman in consideration. Second, even if it is ignored, it will not become workable for the simple reason that when it says that widow will inherit, in same-sex gay couple, who will be the widow? They may say that I'll not claim, but all same-sex couples are not here. They cannot waive their right on behalf of the entire community. And it can never be decided on a case-to-case basis, Manoj.
Could be dependent on the other.
Yes, completely, Manoj. And court also cannot decide, Manoj, if someone dies.
Yes, please.
Yes, Mr.
Yes. Look, these are all interlocked laws. Look, personal laws are interlocked. It's like a jigsaw puzzle. You can't remove one block and replace it with something. Then the entire picture changes.
So you want us to see any other statutes here? That's it. There.
Yes, I'll just illustrate. This is again an illustrative list, not an exhaustive list.
Right. The next now is your Hindu Minority and Guardianship Act.
Guardianship Act,
Muslim Women Protection of Rights.
Kindly, Malord, see the last section 29 on that, Malord, at page 125. Section 6, custody of minor children. This is for Muslims. Again, Malord, man, woman, but kindly see 29. Notwithstanding, I'm sorry. Anything contained in any other law for the
125.
I'm sorry. Yes. PDF 125.
Yes, we got to.
Yes.
Section 29 of
Right.
Muslim Women Protection of Rights on Marriage Act 2019. 29. Notwithstanding anything contained in any other law for the time being in force, a married Muslim woman shall be entitled to custody of her minor children in the event of pronouncement of talaq by her husband in such manner as may be determined by the magistrate. So the custody goes to mother. It will have to be decided who is mother. And mother means the way we understand, the way Parliament has understood. Then your lordships can keep Parsi Marriage Act again. Parsi man means husband and Parsi wife means woman means wife, etc. Christian Marriage Act, similar provisions. But please come to 129.
You know, Mr. Solicitor, talking of the Parsi Act, I mean, just as an aside, this is probably the only act where there's a jury trial.
Yes.
So as single judges of the High Court, and I've sat presiding over a jury trial in a Parsi matrimonial dispute. So you have jurors who will advise you on the on facts. And most of these trials, you're very distinguished members of the community who come and attend and take their work extremely seriously. You might have a top surgeon in the city who has decided
They
to
come
give
as
that one
jury
day.
members.
They come and sit and as jury members in the.
Lord, please come to page 129. I'm just, my Lord, suffering. I'm not reading all. Please, my Lord, read it at leisure. I have highlighted that part which is, my Lord, making it impossible to reconcile, my Lord, if the way they want the Special Marriage Act to be read is in fact read. So section 57. My Lord, this is Christian Marriage Act. Separated wife deemed spinster with respect to after acquired property. The spinster and bachelor has its own meaning, my Lord.
Highly objectionable. This language needs updating.
Mr. You have to amend the act, Mr. Solicitor.
My Lord, this is,
Spinster
your Lordships are right, 1872. 1872.
Time to update ourselves.
Your Ladyship, my Lords are right.
Deemed spinster.
Then, my Lord, your Lordships, my Lord, kindly come to Lord, page 139, Dowry Prohibition Act. But, my Lord, that is read, my Lord, that both can invoke. I'm sorry, Domestic Violence Act is, my Lord, can be invoked by both.
Yes, that's important.
139.
139.
Yes. Penalty for giving or taking dowry. Please see, my Lord, 2A. I'm not reading the whole because it's not necessary, your Lordship.
No. You come to the domestic.
That's at PDF 137.
No, my Lord, 139, my Lord, if your Lordship.
39 is dowry.
139 is
37.
dowry.
Yes, Dowry Prohibition Act.
I thought you were referring to the
I think you
domestic.
please turn to 137.
7. DV Act.
DV Act.
Yeah, yes.
134.
Lord, the DV Act, my Lord. Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. The respondent means any adult person, it can be father-in-law, etc., brother-in-law, any adult male person who is or has been in a domestic relationship with the aggrieved person. Lord, I did not read this because possibly, Lord, this court had, my Lord, a
No,
year
but
or
then,
two.
see, look at the proviso.
Proviso is
Proviso
aggrieved
actually
wife or
for
female living there.
relative of the husband
Yes.
or of the male partner. Therefore, that's where the sisters, I mean,
Mostly that's the-
surviving sisters-in-law, and mothers-in-law, they all come in like.
All are coming, and even brother-in-law.
Yes.
Relative.
So proviso expressly applies to a heterosexual relationship.
Only. Yes. And, my Lord, Dowry Prohibition Act, my Lord, 2A. Nothing in subsection 1 shall apply to or in relation to presents which are given at the time of marriage to the bride without any demand, and my lord, then it says bridegroom without any demand. So again, my lord, what is contemplated is heterosexual couple.
Where is the Dowry Prohibition Act?
Page
Page
138.
138.
Lord, 139, my lord. 138, I'm sorry.
Which provision was solicitor reading? Mr. Solicitor,
Lord, 106, section 1, Lord, item 106, section 3 of the Act, 2A. Your Lordship gets, my lord?
marriage to the bride.
Nothing in this subsection 1 shall apply or in relation to 1A, presents which are given at the time of marriage to the bride without any demand having been made in that behalf, provided that such presents are entered in a list maintained in accordance with the rules made under this Act. Presents which are given at the time of marriage to the bridegroom without any demand having been made in this behalf. So they also, my lord, mention bride and bridegroom. My lord, kindly now turn to, my lord, just as an illustration, my lord, Indian Penal Code. Man and woman are defined under section 10, Lord, 140 at the foot. Section 10. Lord, your lordships, man, woman, the word man denotes a male human being of any age. The word woman denotes a female human being of any age. Then 114, my lord, for example. And my lord, when 1954 Act came, this definition was in existence. The legislature knew what is the meaning of male and female. Well, then section 100 and well, item 114, section 304B, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death.
So suppose a lesbian woman in a relationship.
Even 376 will not apply in the case of same-sex couples who are males.
My lord, 375, if your lordship sees at page 142, it applies only to males. And please see, my lord, I will not read. A man is said to commit rape.
142, is it over here?
Yes, my lord, page 142, section 375, definition of rape. Because only man can be guilty of this offense, my lord.
A man is said to commit rape.
And further, my lord, a man is said to commit rape if he so and so.
Right. You meant something else. If a man, and here I'm not talking of same-sex relationship. If a gay man rapes another man, it is not rape.
IPC, this is that.
That would be 377,
7.
which is, my lord, now which goes.
No.
Without consent is there. Yes, yes.
But then
Still consent 377.
Yes. It is. I stand
I
corrected.
think there is a change in there's a difference in the
Expression.
course definition, but even the penalty also.
Yes. Your lordship, it's only consenting same-sex people.
nature of any man.
Yes.
It's 10 years. And all the other, amended provisions which have enacted gang rape,
Some
370 on women.
Right.
Now, there can be equally same situations on men
Men
also.
also.
They are completely, inapplicable.
But in case of lesbian marriage, my lord, possibly this may not apply, possibly. No, my lord, it may apply if we read man to be woman,
Disparity.
375 B.
Right. Definitionally, it is.
B. If we read man as woman also, then it may apply. Otherwise, the intention is to punish man. That's how it.
Was a definition of.
Yes.
man.
Otherwise, a woman can be guilty, my lord, under B or maybe under C. Not similar is abatement provisions, abatement to suicide under the Evidence Act. If a woman commits suicide, there is a presumption against the husband.
Right.
So again, my lord, we will have to see, my lord, who the person is. But the major problem is in Code of Criminal Procedure. My lord, page 144. Arrest how made. My lord, take a homosexual couple, both man, but one playing the role of a woman. Arrest of how made. Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is
Because in a
committed.
case of a what else, Mr. Solicitor, now after
Yes,
you've seen
Lord.
this?
Lord, last, Lord, I am not taking your lordship, Lord, I have given 160 such similar provisions, my lord. But, my lord, if your lordships can come to 147, my lord. When it is decree and decree is to be executed, even under the Special Marriage Act, my lord, therefore I pointed out section 39A, that decree of judicial separation or will be executed as. There also, my lord, the word is female, male, husband, wife, etc., etc. My lord, I am not duplicating. Your lordships can, my lord.
I think we can conclude this part of the analysis.
My lord, there are, but again, my lord, even if illustrative list is 150 sections of various other statutes. So therefore, my lord, in my respectful submission, your lordships may not give the meaning, my lord, which creates complications then solving the problem. My lord, maybe if Parliament considers appropriate, Parliament may, in its wisdom, my lord, provide for a comprehensive legislature. And as I have pointed out yesterday, wherever other legislative bodies have done it, they have suitably amended other allied laws as well.
All right.
Maybe by the amending act or by one act, my lord, whichever.
Now, what is the next point, Mr.
Now, my lord, next is Gaidan, my lords.
Next
Kindly
point.
come to page 78.
Getan, okay.
Gadan.
Yes, yes.
Which page?
My lord,
Volume?
82.
The other part,
The same.
page 82.
कहाँ पर है गैतन?
82 कह रहे हैं।
Lordships need not read.
Yeah.
Page.
82.
I'm sorry.
Same note one.
Note at this stage, your lordships need not read. I am also not reading. Page 63 to 82, I have produced relevant parts of the judgments which says that in the process of interpretation, your lordships would not interpret contrary to the intent, would not change the structure, would not tamper with the architecture, etc., etc. These are the
right.
propositions are well settled. I'm not, but these are the page numbers.
You
Now,
also
please.
quoted Lord Nichols.
Yes.
Quoted Lord Nichols
Yes.
extensively.
Extensively, my lord. Because that still continues to be a leading judgment on, my lord, where the process of interpretation ends and where the procession of legislation begins. Lord, 78. Lord, I'm sorry, page 82, PDF 82. Lord, the significance is, please, my lord, consider this. In Britain, your lordships are aware the House Parliament is sovereign, it's supreme. There used to be no judicial review the way we understand it, to declare a provision to be unconstitutional. What they do is non-compatible, incompatible. That's how, my lord. That was introduced, my lord, by way of Human Rights 1998 Act. Gedan, my lord, in my respectful submission,
Yes.
yes, my lord, kindly, my lord, allow me to read this, my lord, Gedan, because the reliance is misplaced. Without giving the background and the context. Please see, my lord, further. Apart from the absurdities that the said principles as canvassed by the petitioner may lead to, it is necessary to also settle the issue raised through the judgment of Gedan. It is submitted that reliance on the said judgment is wholly irrelevant to the present case for the short reason noted as under. The system of judicial review in UK and the system of judicial review in India are starkly different. Prior to the enactment of Human Rights Act 1998, there was no judicial review of legislation in UK. Specifically, Section 3 of the HRA 1998 empowers the UK domestic court to reinterpret or force through treaty obligations under the European conventions in local statutes. In Gedan, the court was dealing with an entirely different subject matter of an enactment dealing with rent and not of creating a social institution in the nature of marriage. It was a question of a singular provision to be read in consonance with the treaty obligation and not the case wherein the entire architecture
Yes, please go.
Lord, Gedan was not dealing with, my lord, an interpretation which affected several multiple statutes. But now see the difference in powers available to the court, my lord, in UK and in India, my lord. A bare perusal of HRA, which for the first time in UK provided something akin to judicial review of legislation, would make it clear that the said legislation and our constitution operate very differently in terms of mode and the result it seeks to achieve. The relevant provision of HRA are as under. My lord, then 1 I can skip. Kindly directly come to 3 at page, my lord, 83. Interpretation of legislation. This is a kind of judicial review which is available, my lord, in UK, which is complete, my lord. Therefore, they say that Supreme Court of India is the most powerful court of the world, because your lordships can strike down the provision also as unconstitutional made by the competent legislature. Interpretation of legislation. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the convention rights. But so far as it is possible, it's not a mandate of law. This section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation, or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation, or enforcement of any incompatible subordinate legislation if, disregarding any possibility of revocation, primary legislation prevents removal of the incompatibility. You declare it, nothing beyond that. It continues not only on the statute book, it continues to operate also. That, my lord, comes in further sections. Declaration of incompatibility. Subsection 2 applies in any proceedings in which a court determines whether a provision of primary legislation is compatible with a convention right. If the court is satisfied that provision is incompatible with a convention right, it may make a declaration of that incompatibility. Subsection 4 applies in any proceedings in which a court determines whether a provision of subordinate legislation made in exercise of power conferred by primary legislation is compatible with a convention right. If the court is satisfied that the provision is incompatible with a convention right and that, disregarding any possibility of revocation, the primary legislation concerned prevents removal of incompatibility, it may make a declaration of that incompatibility. A declaration of that, this section, under this section, a declaration of incompatibility, please mark, does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. It's kind of an advisory jurisdiction. It's, as they say, my lord, jurisdiction to nudge the legislature. And, my lord, I have also pointed out that after Gedan, even the courts in Britain have taken, my lord, different view, my lord. Now, your lordships may kindly see in Gedan, my lord, para 148, I have quoted Lord Nicholas. In this context, kindly read, my lord, my learned friend said that now after Gedan, whatever you want to read, you can read into the provision and even alter the statute. That was, my lord, the tall argument which was made, which is, my lord, how legally not sustainable, but the foundation is false. The foundation is that there is an equal jurisdiction between the Supreme Court of India and the UK Supreme Court. UK Supreme Court exercising power of declaring a statute to be incompatible, nothing less than that, my lord. Lord, 147, if your lordship don't mind, if your ladyship don't mind. 84, yes. My lord. It is submitted that despite the wide powers, the court in UK have clarified that the powers are limited, interpreting, not legislating. Even post-Gedan, we can only interpret, we cannot legislate. In considering that is what is possible, the courts have repeatedly stressed the constitutional importance of maintaining the boundary between interpretation, which is, Lord, this is in quotation, my lord, MacDonald judgment, subsequent to Gedan, interpretation which is a matter for the courts and others who have to read and give effect to legislation, and amendment which is a matter for parliament. This is post-Gedan MacDonald judgment. Now, Lord Nicholas in Gedan. Parliament, however, cannot have intended that in discharge of this extended interpretative function, the court should adopt a meaning inconsistent with the fundamental feature of legislation. This was not read before your lordships in Gedan, my lord, by the petitioner. In Rent Act, my lord, the essential feature is not whether the marriage is heterosexual or homosexual. It was rent and the provisions concerning that. That would be to cross the constitutional boundary, section 3(6) to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger and Aylesbury, go with the grain of the legislation. My lord, in my respectful submission, this changes the scenario. In Special Marriage Act, grain of the legislation is heterosexual marriage only. Nor can Parliament have intended that section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Then Lord Reger, my lord, your lordships may, my lords have, my lord justice, in same, my lord Gedan, my lord concurring. What excludes such provision from the scope of section 3(1) is not any mere matter of linguistic form in which Parliament has chosen to express the obligation. Rather, they are excluded because the entire substance of the provision, what it requires the public authority to do, is incompatible with the convention. The only cure is to change the provision, and that is a matter for Parliament and not for the courts. They, like everyone else, are bound by the provision. Gedan says this, which, my lord, was not assisted with, my lord, by the petitioner to your lordships.
Actually, you can see the last portion of that.
Lord,
Report, page PDF 85. 85.
Yes, my lord, 80.
The last
Yes.
highlighted.
What, that is impossible. Yes, my lord. May I read, my lord, the first part also? It does not allow the courts to change the substance of the provision completely, to change a provision from one where Parliament says that X is to happen into one saying that X is not to happen. Then, my lord, bold portion at the foot of this para. For instance, the Court of Appeal held that it was impossible for the court to use the interpretative obligation in section 31 in effect to recreate the fixed penalty scheme enacted by Parliament so as to turn it into a scheme that was compatible with Article 6. As Simon Brown, Lord Justice, observed, it would have involved turning the scheme inside out, something that the court could not do. Only Parliament, not the courts, could create a wholly different scheme so as to provide an acceptable alternative means of immigration control. This is the ratio of Gedan. Now, your lordships may allowed to kindly see para 149.
He uses stronger words like judicial vandalism.
My lord, I didn't read it, my lord. In fact, my lord, this is still, my lord, British language. American judgments are more harsher.
Very sharp.
Very sharp.
Very sharp, my lord. Very.
Because they are not always career judges, you see, in the American Supreme Court. They come from public policy backgrounds, from academia.
They use even sarcasm.
And justice judgments are extraordinarily trenchant.
Justice Kalia, my lord, also. Justice Kalia. Lord, Justice Kalia in this, my lord, Oberfläche has used sarcasm, my lord, while dealing with the further judgment. But my lord, that
Writing that.
Yeah, absolutely.
Lord, para 149. Judicial vandalism, Lord, I avoided reading that part, my lord, but it's not, my lord, I'm just only reading, my lord. It is submitted that discussion of the boundary between legislation and interpretation has tended to focus on two factors. First, it will not be possible to construe legislation in a convention compliant way if to do so would be inconsistent with some important feature of the legislation. The grain of the act, my lord, as they say. And grain is heterosexual, right from the debates till the language used. Secondly, the courts, even in UK, have shown a reluctance to place creative reliance on Section 3 in cases involving complex questions of social policy, which the courts are ill-equipped to decide and which are therefore best left to Parliament. The earlier authorities prior to Gedan and after HRA, which were summarized by Lord Brigham in so-and-so versus so-and-so, it was held that a convention-compliant interpretation may not be possible where it would be incompatible with the underlying thrust of the legislation or would not go with the grain of it or would call for legislative deliberation or would change the substance of a provision completely or would remove its pith and substance or would violate a cardinal principle of the legislation. My lord, this is before Gedan and after the Human Rights Act, my lord, came into effect. Lord, kindly, my lord, come to the next page, my lord.
99.
Yeah, Gedan was 99.
Gaydon was 99.
99.
So the Human Rights Act came into force in 1998.
98. And this judgment, my lord,
Medan is 2004.
no, Gaidan is 2004, I'm sorry.
2004. So it's after the
2004,
act.
my lord.
It's after the act.
It's post-act.
So between 98 and 2004 comes, my lord, this Sheldrake, Justice.
But the interesting part is that concurrently with Gaidan, you have that Civil Partnership Registration Act in 2004,
Four.
around that time. So there was a move there.
Yes, my lord, contemporary move. But that was discussed, debated in public, and thereafter brought by way of a legislature, my lord. And Gedan was not concerned with that issue, my lord. On the subject matter before Gedan was not that issue. Then, my lord, after Gedan, Wilkinson judgment, my lord.
This
Yes.
is also very interesting.
May I, my lord?
We'll continue after that. Yes.
But before my narrative starts, I am told that your lordships were indicated in the morning that your lordships may detach some other matters.
Just that one matter about the notice provision, because, I remember that came up before Brother Narasimha and me in a two-judge bench. He said matter capable of being handled by any other bench also. We'll handle.
Inextricably interlinked, bullets. In our petition, for instance, we have challenged.
But Mr. Ramchandran, that notice issue applies equally to heterosexual couples and same-sex couples.
It would be more appropriate for your lordships to decide that because we've already argued. And secondly, we will rejoin, It's eminently reasonable that this issue be decided.
They have taken that point.
But it's not a five-judge issue. It's a very simple issue of
At the outset, I had pointed out that this is wrongly tagged, if your lordship recollects.
As far as our petitions are concerned, Millets, the right to marry, we contain, Millets, your lordship, remember the group which I represented, it would be illusory unless the notice provisions go, because the
But
notice itself.
that issue is not an issue which is sui generis to same-sex couples.
No, correct.
According to you, one second, according to you, the right to marry even of a heterosexual couple is illusory if I have to step in and give 15 days notice, then, have, people raise objections about, that's the point. So it has absolutely no connect with the issue of whether same-sex couples should have a right to marry. It's irrelevant to that.
The only reason I would urge your lordship, it's a constitutional issue because runaway couples, both heterosexual and homosexual.
Mr. Grover, it's an important social issue, but not necessarily a constitutional issue for a constitution bench. These are matters which every day in and day out are
Mr. Grover.
Before your right to privacy.
Just see what Justice Bhatt is saying.
Of association are actually implicated. They are constitutional issues. It's eminent that the constitution will decides it. Because that be a
Constitutional issue
can be
decided by a 2 or 3 judge bench.
19(1) C and A and 21 we are raising.
Yes, but Mr. Grover,
my lord,
even 19(1)A, Shreya Singhal was not
Shreya
5.
Singhal was 9.
Many of these judgments are not 5 judges. Everything
No, I
should not be
appreciate
elevated to the level of.
already heard it. It would be more appropriate. We can't.
Yes, sir. The only request is your lordship may take a call after the hearing.
One second. Let's the path of least resistance. Learned solicitors on his legs. Let's complete hearing, Mr.
Lordship.
We'll just.
And then but we are putting to you what we'll then put to you at the end of it all also. Yes, Mr. Solicitor. Now, Mr. Solicitor, one request. Please wrap up now as quickly as you can. You have covered the issue of legislative amendments, I think, broadly. I mean, now it's a question of us reading your detailed submission. Now, what remains in this limb of your submission?
Only I want to complete Gedan and this is over.
Which one?
Gedan, my lord.
Gedan, all right.
Gedan, and this is over, my lord. And, my lord, by the end of today, I'll be, my lord, able to assist your lordships with regard to rest of the issues of fundamental rights, my lord, claim, etc. My lord, your lordships were on page.
Ideally, if you can wrap up today by 3:30, we'll be able to go home, and I will be here till late in the night or evening. My learned brothers can go home and get down to tomorrow's files.
I'll, my lord, do.
Yes.
Because that reason is such a strong, my lord, prima facie strong case that I can do nothing, my lord, about it. It's a very strong reason, my lord. I'll conclude that. My lord, kindly come to page 83, my lord. 87 PDF.
Yes.
Lord, I was reading Wilkinson, my lord, post Gedan, my lord. And I'll read, my lord, only the highlighted part so that I can skip the rest. Before your lordship, Miss Dinesh Rose raised with leave an entirely new point on behalf of Mr. Wilkinson. She submitted that it was possible to read section 2.
Widow and widowers, yes. They said you can't read one into the other.
Yes, my lord.
Fair enough. I think let's keep this. You've seen that, no? You don't
Yes,
want
my
to
lord.
read
Now, my
that.
lord, I have quoted the commentary of Bennion, my lord, on the constitutional scheme of British court, my lord, examining in the power of judicial review, if I may use that expression, my lord, because British court, my lord, do not have the power of judicial review. But if your lordships permit, lord, there is one commentary. If your lordships can come to page 90, and the resemblance is purely coincidental, my lord, because this is the only book where I found, my lord, comparative study between
I think you better you better leave the book over there, and you've cited it, and that's about all, I think.
But as a matter of fact, this matter would be the only matter possibly where all three generations are cited.
No.
on the lighter side. Lord,
But you are right, it's the only book on the subject, actually.
Yeah, my lord, we genuinely, my lord, tried and find out what is the comparative study if somebody has done between UK system of judicial review and our system of judicial review.
Yes.
My lord, if your lordship, my lords must have read, my lord, my lords have read it, my lord.
What is the point which is being made in that extract which you are saying? You can formulate it as a conceptual point and then
Yes,
tell.
the conceptual point is this, my lord, that even in Britain, where they are something less, my lord, they have the power which is lesser than power to declare something unconstitutional, which is power to declare incompatibility. My lord, to remove incompatibility suggestion, to suggest removal of incompatibility also, even British court, which relies on Gedan, does not permit re-legislation or changing it so materially that it alters the material.
The grain or the texture.
Grain or the text. The famous
Just
Lord
may
Denning.
not want you to read, but you can read this part. I think this is very relevant for your purposes. Page PDF page 91, and the last part, of the quotation. The major distinction
Where are we?
at the
Page
top,
91.
page
The
91.
major, yes, I'm obliged. My lord, I have in fact marked it in red in my,
Yes.
my lord, I'm grateful. The major distinction between three-stage analysis conducted in India and the UK is the point at which courts progress from stage 2 to stage 3. Two factors indicate that stage 2 is prolonged in the UK since courts in the UK have a larger interpretative toolbox at their disposal than their Indian counterparts. First, unlike British courts, which are quite prepared to adopt the technique of reading in to protect statutory provisions, Indian courts, which frequently read down legislation, consider reading in as an illegitimate interpretative technique. It is in the absence of a Section 3 type mandate, Indian courts remain unwilling to adopt this technique on account of the fact that unlike reading down, reading in involves extending the application of a statute to areas beyond parliamentary contemplation. Here, my lord, everyone suggested reading up, not even reading up, reading something into it which was not, my lord, even intended. Now, my lord, I'll come to the second limb of my submissions, my lord. And, my lord, these are the propositions, my lord. You have copies?
Therefore, actually, Mr. Solicitor, is very interesting because we have a much wider power of judicial review.
Yes.
Therefore, our interpretive techniques are somewhat more narrower than they in the UK. Because the court in the UK does not have the power to strike down as we have. Therefore, they
have a wider.
The remit is this: under Section 3, they can make it compatible. They can make it compatible with the convention, or
declare non-compatible.
Both are possible. So those are the only possibility.
Yes, or they declare that this is not compatible under Section 6.
If they say so, then to make it compatible, it is left to the Parliament.
Parliament.
So in that sense, it's a kind of a continuous interface between the two organs.
Therefore, my lord, the only last bottom line submission is reliance on Gedan and specifically the paragraphs relied upon were not relevant. That's the respectful submission.
This takes us beyond Gedan. The interpretation here.
Yes, my lord. And therefore, the limits of the jurisdiction is narrower. My lord, this is my summary of, my lord, submissions on the constitutional point, my lord. And I'll quickly go through, my lord, my note.
Now we are closing with the legislative amendment part, right?
My lord, there only one point is raised. I'll just in one line say the Supreme Court would not exercise or has never exercised a power of issuing mandamus to Parliament. I have put the judgments. That's all in the first part. I'm not reading them. Well settled. Your Lordships, my lord, yesterday also there is no dispute that there is no mandamus to Parliament that you enact the law, etc. Lord, this is, my Lord, now I am on the second limb of my submissions, my Lord. This is on the claim of fundamental rights. My Lord, my first and foremost point is right to love, right to cohabit, right to choose one's partner, right to choose one's sexual orientation is a fundamental right.
Can you just say that again, Solicitor?
Yes, my Lord.
Just
Right
give me
to-
just 1 second. Just sorry, 1 second. Right to
love, right
Yeah.
to cohabit, right to have sexual orientation, and right of sexual
Instead of saying,
preference.
we'll rephrase it. Right to or can we say it's right to have a sexual orientation? Should we say right to
Exercise
okay,
that
what
right.
would be the correct verb, Ravi? To protect and portray your sexual orientation. Would it
Or
be a verb?
express,
Project,
yes,
project
To
or
project.
express.
My learned
To
brother is
project.
to project. So we'll just take it in its slide. It makes no difference to your submission, but to project.
the sexual orientation
Single partner, you said.
and choosing a partner is a fundamental right. But there is no fundamental right to seek recognition of that relationship as a marriage or in any other name.
What is the last portion? Seek as a marriage in any other name, is it?
Marriage or any other name. Marriage is, my lord, one institution. In some countries, the institution of civil union, etc., is recognized by law. So, right to be recognized as an institution, be it called by marriage or any other name, by any other name.
You're saying all attributes of marriage, if they are there, is not called as a marriage, but something else also is not a right.
Not a right.
Yes. They can cohabit, they can have their sexual preferences, they can express their sexual preferences depending upon the sexual orientation which they have chosen or they have.
And Mr. Solicitor, just to sort of, Sister Hema just told me this, but could we just tighten up your submission by saying when you see there is no fundamental right to seek recognition of that relationship as a marriage or in any other name? Can we recast that by saying
In
to seek
case of
legal
yes, legal recognition.
So
Legal recognition.
Legal recognition is saying.
Yeah, that's right.
You may call it by whatever name or even a marriage. But if you come ask for something from the state based on that relationship, you don't have a right to come and ask.
Yes.
In other words, actually, Mr.
There is no
Solicitor,
affirmative responsibility of the state to recognize.
Suppose a same-sex couple says that, we are inviting a group of 25 friends and we are going to have a marriage ceremony. Our law today, there is no prohibition.
No.
Right? You also accepted it in the morning
Yes,
today.
that you can have.
Fairly, you said that. Well, you can have it. Somebody may have,
Have a reception, or why not?
you will have a reception. Somebody may tie a thali in the south, or somebody may
Yes.
have
Rest also
marriage ceremony.
Saptapadi.
Question is exactly. So, because there is no bar in our law to having any form of ceremony.
No.
Question is about the legal
recognition
so
is
that whether it will be entitled to legal
in
entitlement.
Gujarat, one lady married herself. I don't know how, but in recently, my lord, few months.
Profound.
Hmm?
Very
Profound, I said.
Very
Very profound.
Spiritually very profound, my lord. But anyway, my lord, let's not go.
So what you're saying, what we understand is that there could be a right to cohabit or for a orientation of a particular kind, and give it by any name a relationship which is being sanctified, but that will not have corresponding obligations on the state to do
To
something.
recognize it legally, statutorily or otherwise.
But Mr. Solicitor, let's go step by step. Once you recognize that there is a right to cohabit, in other words, homosexual relationships are not really one-off incidents in the life of a person. They may also be symptomatic of a sustained emotional, social, physical relationship. Once you recognize that the right to cohabit itself is a fundamental right, then to say that you cannot seek any legal recognition at all, because once we accept the fact that same-sex couples have a right to cohabit, then there is a corresponding duty on the state to at least recognize that that cohabitation, all the social incidents of that cohabitation must find recognition in the law.
See, let us take, just moving away.
We're not
from
going
here.
to marriage at all at this stage.
We are moving away from here.
Yeah.
If you move away from the statutory regime, just let us cast ourselves back to the pre-1954 situation. If you visualize here, it means that the law did not say anything about marriage. There was no Hindu code. And yet, the incidents of marriage and the effects of marriage were strewn across several provisions. And we are not talking of only IPC, we are talking of other provisions which confer benefits, which may which may recognize this. Supposing you're working, there's a hard-earned money which you have as gratuity or provident fund, and there is no provision in that to enable the heirs to get it. There is no provision for nomination. So there is an element of, whether you call it a duty or not, as a welfare state, as a democratic state, there are aspirations of the people that there's some recognition somewhere. Now, if the recognition is framed in such a manner that it is acting as an active barrier for this kind of relationship, what is the remedy? At least what can the state do? Apart from we get your basic argument that you cannot read down, cannot read in, etc. How else? Those are 5 or 6 key indicators which they have been mentioning. How does
I understand. The problems which were highlighted.
Cohabiting couple, they have, say, can they not have a joint bank account?
Or nomination in the insurance policy. That certainly, these are all human concerns, which, my lord, I also share and the government also shares.
Difficulties.
Yes, and we must find a solution to that problem.
Solicitor, from that point of view, we would be more than willing to have the government make a statement before us, because you have ministries who are dedicated for this purpose. Ministry of Social Justice and Empowerment,
Social Justice,
Ministry of Persons with Disabilities, Ministry of Women and Child Development. So you see,
you may or may not call it marriage, but some label is necessary.
May perhaps not be. It's a loud thinking. Yes. I may not, my lord, dwell much on that.
I mean,
but in principle, I must say at the outset, as an officer of the court, that except any legal recognition of this form of cohabitation, either as a marriage or by any other name.
We are right now not at that. We are not taking it at that.
There are
other steps right now.
If there are other issues or concerns, they can be addressed on the government.
You have an income tax expert here.
Yes.
You have an AOP. You have a concept known as an AOP.
That's right.
You have a concept known as contract, concept known as partnership. These are illegally recognized.
Statutorily recognized and created.
Right. Point is, yes, I think the key to this is association. Although we have certain other things could creep in once you bring in 19(1)(c). But what you are saying in essence is they have a right to associate themselves. And in that association also means exclusion. In that relationship, there is no other person.
My lord, on that concern issue, my lord, I share the concern. My lord, government also, my lord, I don't think would not.
Exactly. You know, I don't think this will be an issue. That's why we thought that, you know, this should come from you, because I mean, ultimately, you know, we want some element of a broad sense of coalition, because we are also conscious about the fact that there's so much which representative democracy must also achieve in our country. Therefore, we'd be happy to get that kind of
My lord,
assistance from the
I
government.
undertake, my lord, will.
And now take another thing. Today, forget that Kara circular for a moment. We're going to put it to Ms. Bhati later on. One of the couples in a same-sex relationship can adopt. No bar at all. It's lawful. Now, in such a situation, a child goes to school. Does the government want a situation where the child is essentially treated as a single-parent child? Or, and you don't have to go as far as marriage in this as well. See, so we don't have to go for an all or broke approach, at least at this stage of the development of our social ethos. Would the child not have the benefit of the cohabitation between the two people who have in whose home that child resides? You know?
This is more, your lordships are right. I understand the concern your lordships have. If one can, my lord, why not two? Merely because they happen to be sharing the sex.
There is an issue there. And that's a very correct, I mean, concern. If there are two, then both have to be recognized. It can't be that one relates to one and the other one relates to the other. So both children are the children of both those parents. From your angle, there could be something else in your mind, which also, I mean, cannot be wished away. But at the same time, if this is normal for them.
Well, this is more a sociological problem.
Yes.
The rearing of the child, development of the child. Maybe, my lord, these are all hypothetical situations, and my learned friend will deal
But they are
with it.
real life
No,
situations.
they are not hypothetical.
They are real situations.
What I'm going to submit is a hypothetical situation.
Right.
That there are studies which show that a single parent child, his growth is different and better than the child who does not see mother and father both. He sees either two men or two women. But the difficulty is this, and I'll very candidly share this. My lord, this movement, my lord, this kind of, my lord, orientation must be in existence since time immemorial. But this movement started in 2002, around 2002.
Actually, you know, Mr. Solicitor, it's the other way around. You see, it was the impact of British Victorian morality that we gave much of our that we had to forsake much of our cultural ethos. You go to some of our finest temples, which reflect the architecture.
I understand.
And even if you look at them, you will never say that this is either, you know, lurid or that it is depicts some emotion.
No, I was slightly on a different point.
It shows the depth of our culture. So what really happened?
It's a very layered culture that probably
It's
those layers
educative.
actually
Others
It
imitated
was intended to be educative.
And look at the great
It was very pragmatic and educative.
look at the profound nature of our culture down the ages. What happened, unfortunately, was come 1857 and thereafter, and you got the Indian Penal Code, for instance. We imposed, as it were, a code of British Victorian morality on a completely different culture, and our culture was extraordinarily inclusive, very broad, and which is possibly one of the reasons why our religion survived even foreign invasions, because of the inclusion, the sense of tolerance,
of the culture.
the breadth and the profound nature of our culture.
Absolutely. My lord, I was on a slightly, my lord, different point.
So, you know, the reason why I'm saying this, Mr. Solicitor, is this, that there are so many issues in which you can, in that sense, we also understand our limitations as a court. I mean, there's no question about it. But there are so many issues in which, you know, for instance, of course, you have made your argument on the legislative side, but there are so many issues on which, on the administrative side, your ministry
I take it, my lord, and
can find real solutions to these problems, and maybe we can be acting as facilitators to achieve these
certainly, my lord, and there, my lord, there would not be any adversarial stand.
And the relationship of the court with the government in that sense is not really an adversarial relationship.
Cannot
so
be,
much
and
of the work
especially
which
in
we
a
do,
matter involving human.
we're constantly, especially on socio-economic matters, we are pushing the government. We are asking them, come back. Give us.
So I'll speak to Malord at an appropriate level and respond.
We may not have a model within us, and it may not be appropriate for us to devise that model.
Absolutely.
But we can certainly tell the government, but now look, our law has gone so far now. Now, within what our law has recognized, can we not ensure that, there is a certain degree of...
Class-specific problems can be addressed to and attended with a view to solving the human issues. I understand.
Day-to-day issue.
See, look at it from another angle. You've shown us the international scene. Unlike in other countries, there has been no prohibition for this kind of marriage, right? In that sense, except 377, which criminalized this.
We didn't have any law.
We did not have any law. So, which means that society by and large was where it stood. It was accepting the way things were. But now we have progressed somewhere. We have decriminalized it, and there is some sense of that identity. That identity, how do you handle it as a democratic government and as a system?
As my lord, the Chief Justice, my lord, said that as a social welfare measure or as a welfare state.
And Solicitor, look at it this way. Despite the government's stated position on affidavit before us, we have a law as far-reaching as a transgender act.
Look, kindly have a look at
it's a law of 2019 and look at the vision of that legislation.
Look, kindly have a look at it.
See, just to supplement what the Chief Justice has said, we had a Vishaka. Vishaka was limited in its application to public sector and the state agencies, and rules were amended. Eventually, that got assimilated, and it's a wider enactment which applies to all establishments. This provided different mechanisms which even the court could not visualize. Then domestic violence was also, the enactment was a result of some movement, sustained campaign, etc. Then came the Transgender Act, which is also, in that sense, this constant collaboration has been happening.
Certainly, on Vishaka, I have separate a limb of submissions because that was a complete vacuum.
You're absolutely right.
An absolute vacuum.
And I tell you, Vishaka was an easier.
It was a regulatory mechanism.
Another thing you see
of an admitted fundamental.
Another thing, Vishaka deals with an issue, a social issue which does not have interlinkages. You have sexual harassment in the workplace. You have models of disciplinary inquiries, which is a part of our jurisprudence. So what we did was we internalized that, created, the sexual gender sensitization committees. Complaint will be heard by the gender sensitization committee, and that person will be dealt with. Okay, so it was a workplace. It was defined by a physical workplace. So it was much easier.
The identifiable class, identifiable inhabitation, and identifiable issue.
So the canvas was smaller.
Very.
Therefore, it was open to the court there to say, as our court said, that in view of CEDAW, pending the creation of legislation, this is what the framework that we will adopt. This case is much more difficult for us to do that because, it's not that, you have just one silo. These are not silos. These are, these have linkages everywhere.
It's a consent order.
Succession, adoption, maintenance, everything. So
even domestic violence, there was a felt need. Otherwise, the legislation has gone this far as to recognize live-in relationships, a right to residence. So there can be situations where the live-in relationship, the person in a living relationship who lives for a long time might well get back if she is thrown out. She might get an order for coming back to the same house where both the man and his wife are living. Now, there's a recognition, there's a right to residence and all the other rights around it. So it's not as if things are working in their own silos. That too has linkages with family law.
Correct, my lord. But my lord,
when we say
it will have to, my lord.
When we say recognition, shouldn't always mean recognition as marriage.
May not.
And recognition of
it means association, which should entitle them to certain benefits.
That's all.
Not to say that once we say that once we have accepted the identity and association of two persons should not automatically mean that their association is actually equated to marriage.
Common parlance.
You know, Mr. Solicitor, the old Privy Council principle, long cohabitation itself raises the presumption of marriage. Why? Because in the olden times, I mean, I don't think at least in our parental, you're much younger than all of us, but in our parental time,
don't look.
Where were the marriage
for
certificate?
either of us, that
Tell us where
statement
were
is
the
wrong.
marriage certificate? Where were the registration? Mr. Dwivedi just said that he doesn't have a registration.
Neither do I.
Who had the so therefore we developed the concept of the presumption of marriage out of long cohabitation. And that has something, that's a very important principle which we have adopted. So if there is in that sense, we are not going to marriage right now at all. All right? That's not the purpose. But therefore, I think the reason why we are trying to push you to this, and let's be very candid about it also, the reason why we are pushing the government to this is because we take your point that look, if the court were to go into the legislative arena, you've made a very powerful argument on that look, you'll be legislating. This is not your remit. This is for Parliament or the state legislatures under entry 5 as we put up front. But short of that, our law has gone so far now. Now what does the government want to do to ensure that these cohabitatory relationships, if I can call it that, the relationships based on cohabitation, on association, Brother Narasimha says, they must be recognized in terms of creating conditions of security, social welfare. And to ensure, by doing that, we also ensure that for the future, that these relationships cease to be ostracized in society.
No, that is transgender sex. I can show, my lord, the entire scheme.
Solicitor, I would like to pose a question. See, with the decriminalization which took place,
yes,
obviously this was indirectly a recognition that such a status can prevail. Once such a status can prevail, logically I would think that different social ministries would have possibly, I don't know, would like to know, gone into a study of how to tackle these very other problems which would arise from a continuation of such status. After all, when you say living in relationship, that's also not given any other sanctity, but the social legislation took into account that aspect. So when you talk about a homosexual relationship and people staying and decriminalization, coming out of the closet, the next question would have been, how will different legislation areas where interests would be involved of two people or more than two people, like the adoption case Chief Justice talked about, would have logically, to my mind, given a thought in the ministries to think about it. Has such a thought process prevailed? Because I at the cost of repetition, agreeing with the Chief, feel that this is, let's not transpose the Victorian philosophy as our original civilizational philosophy. That would certainly be difficult to accept. So you may also check up whether any thought process has been worked out in the concerned ministries dealing with such aspects, or any thought process has been given to it in the last 5 years.
Yes, well, once it has fallen from your lordships, it's my duty. I'll point out and I'll my lord, find out and respond. But my lord, in my submission, my lord, in my understanding,
we'll request you on this to assist us in a non-adversarial way.
And my lord,
I will request you to assist us in a non-adversarial way on this.
Yes, yes. Yeah. Lord, the elimination of the problems which faced by them, Lord, regarding, my lord, as pointed out, my lord, nomination.
The human angle.
A human angle. That, Lord, anything, and my lord, but your lordship's decriminalization would not, my lord, be understood and has not been understood by the government also as a recognition of any status. Apropos, my lord Justice calls, my lord, query that your lordship decriminalized a particular activity which was till then an offense, but that did not give any status to the relationship.
No, it recognized the existence of this situation. Yes, it recognizes that it's no more a criminal activity, it's an existence of a relationship, existence of a situation.
And that can continue. There is no prohibition against that continuance of the
Mister,
activity.
when we say that a live-in
No,
relationship,
there are large number, I'm sorry.
no, a live-in relationship also, in a sense, falls in that category where you say that there may not be any marriage, may not be recognition, but certain obligations would follow. Similarly, gay people living together may not be married, decriminalized, open. Such situation would prevail where problems are bound to arise in different aspects of legislation or social requirements.
Yes, my lord.
That's what I wanted to know. Considering the social requirement, like examples given, whether of bank accounts, of adoption, of so many other things, the inconsistency which would come in when such people come out into the open is an aspect. I thought maybe the government had thought about it, something about it.
Yes, I'll find out and respond. But
Assuming they haven't.
But, my lord, I make it clear that I would not assist the Honorable Court qua,
Yes.
my lord, so far as possible and legally permissible, the removal of the problems they are facing.
Barriers, actually.
Not, yes,
barriers.
my lord, not, my
And
lord,
somewhere, some semantics have to be.
without any legal or statutory recognition.
Solicitor, one caveat is necessary. When you do remove it, the semantics of it are equally important. How do you treat them?
Yes, yes.
You may or may not call them spouse, but nowadays there's a more neutral word there. The neutral word is partner.
Partner.
That's a partner is a very neutral word which is being used. That's in currency now. So which is the appropriate terminology you would like to use? Those also have to be, otherwise, it might be counterproductive. There may be nothing.
Yes.
Well, the concern is that you may not want to confer a particular status.
Recognition.
At the same time, there is some need to bring down those barriers.
Lord, that whatever administratively can be done, my lord,
This is, Mr. Solicitor, completely in line with what you were suggesting. An issue like this, the remit is actually with the Parliament or with the executive to take into account. So therefore, we were putting it to you only.
Certainly, my lord, and I can assure your lordships, my stand would on this not be adversarial. And my lord, I'll talk to the government, and my lord, whatever best on those human issues, my lord, can be done. My lord, we are not that way, my lord, adversarial in that sense.
So because now after we break today, tomorrow is miscellaneous. Monday, Tuesday, my learned brother Justice Nasma is not in court. So we meet on Wednesday. So you have that time to, come back to us and respond on Wednesday.
Lord, shall I finish this or my lord? Or do
no, you wrap up on this now.
Please.
And you
Lord, kindly have this. I'll just quickly go through this.
Let's quickly run through it.
There is no fundamental right to get all types of social relationships like marriage recognized and registered. There is no fundamental right. Well, that's the thirst and respectful, Lord, very emphatic submission on my part. Then Article 14 argument, Lord, while challenging the Special Marriage Act, they say the Special Marriage Act is violative of Article 14, to which I say, Article 14 applies when government has created a mechanism for different classes, though they are same or vice versa, which is not the case here. Or act has no nexus with the object it seeks to achieve. These are the two ground, my lord, for Article 14, my lord. We may call it arbitrariness, we may call it by any other name, but broad categories are this. My lord, here the Special Marriage Act is only for heterosexuals. And that's what, my lord, the debate also clearly show, and the language and architecture also clearly show. Yes. And the object is intra-faith and interfaith, intercaste marriage. And it seeks to achieve that, my lord, and there is no provision contrary to that. So, when you want recognition of a particular class of people in a particular class of relationship, it cannot be said that the other class legislation is violative of Article 14. Well, that's the submission. Now, petitioner wants a new class to be created. I have already made submissions for an entirely new object, which was never conceived at the time of, my lord, enactment. Now, my lord, there is no positive obligation on the state to recognize every social or personal relationship. There are a large number of relationships in the society. All need not be recognized. As a matter of fact, Lord, this is something very, very crucial. The state should be very slow in recognizing the relationship, because state is entering into the arena of socio-personal relationships. It can recognize only when it finds that legitimate state interest requires regulating them. And you can regulate only if you recognize them. So marriage also in heterosexual, ideally, should not have been regulated. But the society felt that you can't permit people to marry at any age. You can't permit people to marry as many times as they want. You can't people to stay together for 10 years and without reason part ways.
Yes.
You can't stay together for 10 years and part ways. And therefore, marriage was recognized with a clear legislative policy that it would be heterosexual, and regulation followed. So, my lord, the point is that there is no obligation for the state to recognize each and every social relationship.
Yes.
Then, choice of a sexual partner is a fundamental right. Right to get legal recognition of such partnership is not a fundamental. Then there is an intelligible differential between heterosexual and homosexual persons, as constituent units in both the classes are different. Heterosexual, my lord, has constituent units which are, my lord, of opposite sex, and homosexuals as a separate class has a different constituent. So it's not, my lord, that unequals are treated equally or equals are treated unequally. That's not the position. My lord, for example, zinc and brass both can be metals. No one is inferior, no one is superior. But they are treated separately. That's as simple as that. Then Article 14, 15 and 21 can be invoked only if law imposes prohibition on homosexual couples in their freedom of choosing sexual orientation and exercising their right in privacy, and not on heterosexual couples. If they say that heterosexual couples are permitted and we are prohibited, then, my lord, possibly 14, 15, 21 may come into play. Now, classification is based upon the nature of relationship and not on the basis of sexual orientation of individuals. Both, my lord, in Hindu Marriage Act as well as in the Special Marriage Act, the pith and substance is the nature of relationship, not your sexual orientation. And therefore, I say Article 14 prohibits class legislation and not classification per se. What we have done, what the legislature has done is classification which has intelligible differentia. Both are, my lord, different. Then Transgender Persons Protection Act provides for an affirmative classification in favor of one class mentioned in section 2K to protect Article 14, 15, 19 and 21 rights of all categories of LGBTQIA plus persons. Lord, if I show your lordships broadly the scheme of this act, Lord, first of all, transgender, the way in which we understand in colloquial parlance, which is equivalent to eunuch, general, that's not the way it is defined. Lord, for a second, if your lordships can just have a act, my lord. It covers all spectrums and shades, which, my lord, I have described yesterday. 2K. Does your lordship get 2K? Please see, my lord, widely worded, and I'll just read, my lord, the headings of the section. Transgender person means a person whose gender does not match with the gender assigned to that person at birth. This is the conventional, traditional understanding.
This is the first part, and then the second part is the inclusive part of it.
Yes, my lord. And includes, it widens the scope, trans man or trans woman, within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy or such other therapy. Natural as well as artificial, both. Person with intersex variations, gender queer, and person having such socio-cultural identities as Kinnar, Hijras, that is again not the conventional understanding of the term transgender. In between, my lord, every other spectrum is created, and my lord, gender queer and person with intersex variations include all categories. And just have a look at, my lord, prohibition against discrimination.
But, Mr. Solicitor, everybody who is an L or a G, the lesbian or the gay community, they're not transgenders.
They would be gender queer.
No.
Lord,
No, Mr. Solicitor. Somebody who is gay is not a person whose gender varies from what is assigned at birth.
Yes.
Their gender is exactly what is assigned at birth.
He is a man, my lord.
Born a man and continues to be a man. Born a woman and continues to be a woman. So they are not transgenders, therefore.
Lord, even bisexuals are not.
Undertaking can be given, we can give an undertaking with that effect.
क्या बोला, sir?
Don't correct Mr. Solicitor.
What did Mr. Kripal say?
I am not disputing that. I'm not disputing.
Yeah.
Lord, LGB, then we are on T.
Right.
T is transgender. I say transgender, colloquially understood, is similar to, my lord, Kinnar or Hij. Anyway, don't get...
No, Mr. Solicitor, you may be right in this, that the definition of transgender in this act covers the entire spectrum.
That's all I'm saying. I'm not, my lord.
But covers the entire spectrum of transgenders. But yet, the community of gays and lesbians is completely distinct from the transgender population.
It does not cover the entire class.
Yeah,
I mean, if
exactly.
you put them all as one class, LGBT,
It's not an interchangeable.
they're not there.
Lord,
Clarify, I don't want to. There's transgender as opposed to that is cisgender.
CI.
Right.
So that is a distinction.
And sexual orientation.
So a cisgendered person cannot be a transgender.
Exactly.
And sexual orientation.
My lord, the definition is this, my lord. Definition is this. Of course, this question doesn't fall for consideration, but definition I'll just read, my lord. Gender queer, denoting or relating to a person whose gender identity does not correspond to the conventional binary gender distinctions. Anything outside male, female, or male, female, but having a different feeling than what he is assigned. That's how I have understood. My lord, I may be wrong, I may be right. My lord, I don't claim to be an expert on this subject, my lord. But this is a very widely worded subject.
This gender means the gender which...
The gender outside the binary.
No. See, cisgender is the gender you are born with. All right? The gender which you are assigned at birth. Now, I'm not talking of the entirety. There may be some variations. We're not talking of exceptions, aberrations, not aberrations, sorry, but some exceptions and variations. As a principle, lesbians belong to the cisgender category because there's no variation between the gender with which they were
Their
born.
feeling maybe is different.
There's no reassignment, or there's no question of assuming a different gender later. Therefore, they don't fall in the T of the transgender bill at all, or the transgender act at all.
That
They're a completely
man
different
trapped
category.
in a woman's body or something. My lord, I read somewhere. My lord, I may be pardoned if it's not a correct word or a bad word. My lord, that's how, my lord, I understood it to be. But, my lord, it's a very widely worded definition of
Of course, there you are right. It covers the entire gamut of transgenders.
Yes.
You're right. To that extent, you're absolutely right. But no.
Now, your lordships, my lord, kindly in this context, turn to section 7. My lord, first of all, see the title of 3, prohibition against discrimination. Right? Several kinds of discrimination, employment, admission, public places, etc., etc. Then recognition of identity of transgender, application for certificate, issue of certificate. Please see 7. Well, that might, my lord, in this context, my lord, assist your lordships. After the issue of a certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application along with a certificate issued to that effect by the medical superintendent or chief medical officer of the medical institution in which that person has undergone surgery to the district magistrate for revised certificate. He can undergo a surgery and male becomes female, female becomes male. That obviously not based upon genitals. And thereafter, the first certificates is now provided to be changed as per the provisions under Section 7. He gets a new certificate as per his new gender identity.
Solicitor, if really the concerns of the gay and lesbian community had to be addressed, possibly, I'm just thinking aloud, possibly a legislation specific to that, as it has come for transgenders, would have addressed the issue. But it can't, those concerns will not be addressed in the Transgender Persons Act. That is the only problem.
The stigma essentially, historically and socially, is with regard to transgenders. There are several persons who belong to either G or L in LGBTQ, but they are not that way stigmatized or getting any problem with the.
They were very badly stigmatized.
Yes, stigmatized.
In fact, the parliamentary debates on the 1954 Act itself shows, that there was a considerable degree of social stigma attached to it. Or even the
Not
LGBT
comparable to transgenders.
No, you see, if it is known, why is it that people were not coming out apart from 377? There was a
Again,
social
we are entering into a debate which possibly this forum is not meant for. Needs assistance, my lord. What is what?
This is arising from what you said. It is arising from the fact that the Parliament did take a good and a long step ahead in legislating on this aspect.
Correct.
Having legislated on this aspect, what we had put to you was, at least I put to you was, that possibly the addressing of the concerns of the gay and lesbian community similarly could have been only through a legislation which dealt with these, what you call.
Yes, certainly, my lord. I bow down. The legislature could have and can still do that. There is no difficulty on that proposition.
That the way forward is not to read into it, into this act, the problem of the lesbians and gay community, but possibly it's a legislative exercise. We can't issue amendments.
On that proposition, I have no quarrel. Your lordships are absolutely right. Now, my lord, if I can, my lord, quickly run through, my lord.
Which point, Solicitor?
My lord, kindly take my second note, my lord. I'll just quickly, my lord, take your lordships through by, my lord.
The one we were reading?
The second note, my lord, which is filed yesterday.
Yesterday.
Note 2.
Yesterday.
Filed yesterday.
Oh, note 2, which was filed yesterday. I thought.
Which begins with the observations of other constitutional courts. Is that the one?
Yes. My lord, I have quoted.
Yes.
My lord, the minority view. My lord, when I say minority, it's 5-1 razor thin minority, but 5-4. I have quoted, my lord, from the minority view. A little harsh, my lord, but on merits as well as on the jurisdiction.
Yes.
My lord, I wish I can read to your lordships that, my lord, but my lord, if time permits, on the next occasion, but otherwise, Chief Justice's, my lord, dissent is beautiful. Little harsh, my lord, that's the way American judgments are written, but on merits also, and even on the question whether court can do it or legislature can do it. My lord, please come to page 10 directly. My lord, I'm sorry, 13, PDF page 13.
Para 5?
5, my lord. My lord, I have given, my lord, numerous international judgments, my lord, other than which we have already pointed out, my lord. This is first judgment of the New Zealand, my lord, United Nations Human Rights Committee's judgment. My lord, please see the last part. Article 23, paragraph 2 of the covenant is the only substantive provision in the covenant which defines a right by using the term man and women rather than every human being, everyone, and all persons. Use of the term man and women rather than general terms used elsewhere in part 3 of the covenant has been consistently and uniformly understood as indicating that the treaty obligation of state parties stemming from Article 23, para 2 of the covenant is to recognize as marriage only the union between a man and a woman wishing to marry each other. The committee cannot find that by mere refusal to provide for marriage between homosexual couples, the state party has violated the rights of the authors under Article 16, 17, 23, so and so of the covenant. My lord, then is the Thailand.
But just in the last sentence also, it may be noted that there are other opinions of the HCC taking a different view on the issue.
Yes, I have said so. I have said so. And we have cited and we have placed also. Yes. Well, whatever is there, my lord, we have not been selective, my lord, I can assure you.
Yes.
Then Thailand. It upheld section, Thailand court, my lord, upheld section so and so of the Civil and Commercial Code, which permitted marriage only between a man and a woman. It held this was in accordance with the state of nature and Thai custom. It is further held that sex means biological characteristics. The court noted that purpose of marriage was to create a family and that marriage between people with gender diversity would not be able to create the same bond as a traditional marriage. The court noted such persons were deserving of general protection but under special marriage laws. The court held that the equality guarantee in the Thai constitution applied to persons with equal characteristics, but people with different essential characteristics would have to be treated differently. Then, my lord, Panama is a beautiful judgment. I have only quoted a part. My lord, it's again, my lord, translated. So, my lord, translation is Google translation. Generally not wrong, maybe a little inaccurate here or there. The Supreme Court of Justice 2023 rejected the right of same-sex marriage, holding that Panamanian laws conceived of marriage as a bond between a man and a woman, and the same could not be judicially rewritten by the courts. Although the petitioners relied on a decision of the Inter-American Court of Human Rights to claim that recognition of same-sex marriage was an obligation, the Supreme Court held that the court could not adopt an international law interpretation which was conflict with the country's internal law, and that any such addition or expansion of the right must be done with the consent of the state expressed through the concerned agency, in this case, the legislature. The court further held that since the right to marriage is in Panamanian law was based upon the idea of one man and one woman, the right to equal marriage could not be claimed as a fundamental right. Then your lordships can, my lord, skip. My lord, Peru, Poland, Philippines, my lord, your lordships, my lord, my learned wants me to read para 13, my lord, that is 17, last portion, my lord, of Panama, my lord, again. He thus concludes, your lordship gets, my lord, he thus concludes that the state can prioritize one union over other, taking into account the value it assigns to it. Thus, the preference of the state for the matrimonial union over the homosexual union has reasonable grounds that legally justify it and prevent the distinction from being qualified as discriminatory. Then, my lord, on the next page, last part, my lord, so and so are objectively and reasonably justified in the general interest of giving precedence to those unions with the potential to establish families in their original conception, give continuity to the human species and therefore to the society. The difference in treatment, which is not discrimination in the pejorative sense of the word, is based on the immanent purpose of the classical marriage institution, etc. Then Poland and Philippines, my lord, your lordships can skip. My lord, I have argued, my lord, substantially, my lord, I have given the I have given, my lord, the gist of Article 14 argument, my lord, at page 18. I am not, my lord, reading it. In my, my lord, summary of submissions, I have given that, my lord. My lord, there is one judgment which I would wish your lordships, my lord, to read. That is Special Courts Bill. It's a 7-judge bench judgment, my lord. That is on classification and, my lord,
79.
79.
70. Well, your lordships have seen it, but I don't. My lord, I have quoted the relevant part for your lordships
The
immediately.
principles are formulated.
After Dalmia, this was
This is the judge. Yeah, lordships, my lord, I'm grateful, my lord. I'm absolutely, my lord, grateful. Then, my lord, page 29. Under inclusion, my lord, Kedarnath Bajoria.
Yeah.
My lord, I rely upon this judgment, my lord, which says, now only the highlighted part, my lord. Now it is well settled that equal protection of laws guaranteed by Article 14 does not mean that all laws must be general in character and universal in application, and that the state is no longer to have the power of distinguishing and classifying persons or things for the purpose of legislation. There are 5-judge bench, but the last 4 lines at page 29. Article 14 does not insist that legislative classification should be scientifically perfect or logically complete, and we cannot accept the suggestion that the classification made in the Act is based on no intelligible principle and is therefore arbitrary.
Economic regulation.
different scrutinies when it comes to this also. When you're
Different, I'm sorry.
See, like
Scrutinies, yes.
scrutiny, because we don't use that sliding scale as a principle, but when it comes to fundamental rights, it's a closer scrutiny. Whereas when it goes to economic,
Threshold is high.
so intermediate is somewhat like, say, beneficial social legislation, social welfare. Economic is as hands-off as possible.
Lochner and my lord,
No,
down the line.
our own, our own.
Your lordships, my lord, I
Because
understand.
14
But the
comes to-
difficulty is, my lord, your lordships are examining the validity of Special Marriage Act. Even if that is held to be unconstitutional, my lord, no relief can be granted. That will be the threshold, my lord, at which your lordship would test the.
No, then you go only by the classification theory, whether this left out clause is part of that clause.
Correct.
And
If they are.
go back to that first.
Yes, my lord. Then, my lord, classification not on the basis of sexuality, basis is honorific status of heterogeneous institution of marriage. It should be heterosexual. Article 50.
Yes.
Article 15. That classification is not based on sex. Classification is based on the marriage as an institution. So there is no violation of Article 15.
But the exclusion is based on sexual orientation. That's the argument.
Yes, yes, but there is a reasonable basis. There is a reasonable basis. My lord, exclusion per se is not impermissible. Exclusion must have some logical, intelligible differential. My lord, if suppose.
Again, your argument perhaps can be seen from this angle.
Yes.
Supposing there were no statutes. Supposing there were no Hindu Marriage Act, there were no Special Marriage Act, there was no enabling legislation at all. The institution of marriage exists. That institution of marriage has come up, grown up from the whatever social roots, that has only this model.
Yes.
Now, where is the, and then if that is recognized by law, and not in the sense that you encode a rule, but you recognize that and provide for that, can there be exclusion? Can there be a
It's non-inclusion, not exclusion, my lord. I would respectfully urge this is the difference. Non-inclusion for a good justifiable reason. Exclusion, my lord, necessarily mean something which ought to have been included but excluded. This is a separate class by itself. My Lord, Lord, I have
Just 1 minute.
page 30, Lord, I have said, my Lord, I have quoted from an article, and I'm sure there must be articles taking a contrary position. I must, my Lord, be candid with your lordships. The articles, my Lord, are on this side and that side both. But one's theory, my Lord, is that, of course, being born gay or lesbian is innate or it's by birth, but it is also an acquired quality in many cases. That's the view. Lord, your lordships would not accept one and discard other, because ultimately these are views and theories based on which, my Lord, no argument legally can be based, my Lord, in a court of law. I'm just, my Lord, placing it for your lordship's consideration, because this can be one of the considerations as and when, my Lord, the legislature takes the call. Then, my Lord, page 34, 33, my Lord, I'm sorry, PDF 33. I have cited some judgments on this, my Lord. Similarity of outcome is not necessarily the import of Article 14.
That's okay. Now we can.
Yeah, my Lord, your lordships,
You can just read
no,
the
my Lord,
heading.
it's a very, very.
Just read the heading.
Yes, my Lord, kindly come to 38, my Lord. Lord, Mr. Rodgi said false equivalence claimed through scientific techniques, that we can also be parents by artificial insemination, etc., my Lord. We have given, my Lord, details. Again, my Lord, the material available which goes to suggest, my Lord, that that theory may perhaps not be a very accurate theory. Then, my Lord, 40. Lord, personal liberty. Lord, I have said that personal liberty is protected. For personal liberty, marriage is not a sine qua non. That's my first point, my Lord. Article 21, right to life. The derivative right is to cohabit. Right to life per se, verbatim doesn't include right to cohabit. There are certain derivative rights your lordships have read. Right to education, right to shelter, right to dignity, etc. So this is one of the derivative rights. So for that, for enjoyment of that right, you don't need a recognized institution of marriage being recognized by the either court or by the legislature, my Lord. Then, my Lord, 42.
Yeah.
Lord, legitimate state interest of ideal mode of child rearing. Lord, this is the reason why the state prefers, and throughout the world, almost every country, how many total countries? Out of 194 countries in the United Nations, your lordships have seen few of the countries which have legitimized or legalized this. And this has remained the core of their decision making. And, my Lord, now, my Lord, page 46. This is what, my Lord, I was saying. Lack of data to establish equivalence with biological heterosexual. My Lord, kindly allow me to, my Lord, correct this, not heterogeneous, heterosexual upbringing. Now, what has happened is, Lord, this movement started somewhere 20, 30 years ago. So we don't have, my Lord, any data. The first or second generation are there. So what is the effect on the children? Very few may have adopted the children. There is no, Lord, reliable data. Data is both sides, but they lack the very basic foundational facts to arrive at conclusions. So, my lord, right now, it would be, my lord, hazardous to make any guesswork on that. My lord, that's the point. And, my lord, essentially, articles, my lord, I will not trouble your lordships with. Now, PDF 52. My lord, PDF 52, your lordships have. Substantive due process. My lord, I need not labor much on this point for the simple reason that, my lord, the Chief Justice of India has, my lord, at page 62, 60, sorry, my lord, 60, PDF 60, discussed everything and summarized everything in para 296 of Puttuswamy judgment, 9 judges. 62, my lord.
Sorry.
PDF, I'm sorry,
62.
PDF 62. 60, my lord, I'm sorry, 60. My lord, this is on the substantive due process. I have cited the case law and ultimately what is the view of our court, my lord, by my lord Justice, Chief Justice, my lord, in para 296, which I have quoted at 57. Then, my lord, Article 19, right? Freedom of expression. My lord, expression of love, expression of compassion, expression of concern doesn't need an institutionally recognized form. A friendship is an expression. Lord, page 61, 62, response to challenge on the notice and objection regime. Your lordships are right now not going into it, my lord. I am not taking your lordships, my lord. 65 onwards, my lord. 65 to, I have given the international position, my lord, till 73. My lord, what the proposition is this, that judicial precedents of other jurisdictions cannot be blindly relied upon because the fact situation, the societal ethos, cultural values, various other factors, historical facts, the jurisprudence of every nation is different, my lord. So that's what, my lord, I have given the judgments, my lord. Then, my lord, 73, inapplicability of international treaties. My lord, they relied upon some international treaties to seek a writ, my lord. Lord, there only one judgment, my lord, I respectfully place reliance, and that's my last point, my lord. I my lord, conclude at 3:30, my lord. And if need be, my lord, I'll have some time on Wednesday, my lord. If
GVK.
Gramophone, my lord, yes. Justice Chinapareddy, my lord, I did not.
So there are two. One is Justice Chinapareddy, the other one is Justice Sudarshan Reddy.
No, my lord,
GVK is Justice Sudarshan Reddy.
the GVK, but this is, my lord, Gramophone company.
That's 84, yes.
Yes, 1984.
The points that you want to make on this?
Well, there is no treaty obligation argument permissible. Only one para, my lord, at page 73. 74.
Right.
The doctrine of incorporation also recognizes the position that the rules of international law are incorporated into national law and considered to be a part of the national law unless they are in conflict with an act of parliament. Lord, thereafter, my lord, I have given at page.
Let them also think.
Miscellaneous.
Now, on Wednesday, who will follow?
My
Solicitor,
lord,
you want to wrap
my
up?
lord, if required, my lord, your lordship may give me.
Certainly, if required.
Yes.
Mr. Devedi, what we would request you is if you can just give us maybe a page of just crisp submission. Mr. Attorney, you'd like to argue on Wednesday after this?
Sir, I have some personal difficulty. I will not be here. Then, Lordship,
I will
for the next hearing, then I will.
Then you can start.
Monday I'll circulate.
Just maybe a page or 2 pages, just crisp bullet point, because then we know, what is the line that you are going to be taking, on which aspect are you going to argue, Mr. Dwivedi?
Lords, I'll just touch upon the act and the separation of powers a bit, my lords. And then, my lords, address on this claim of equality of status, my lords, which the other side is claiming, my lord, with the heterosexuals. And some feature of the statute also, my lord, the Special Marriage Act, not
All right.
so.
Fair enough. And after Mr. Then Mr. Datar will argue, or?
Datar is appearing for Gujarat, my lord, so he will.
No, he's not for Gujarat.
Not-
Gujarat, my learned friend appears, my lord.
Manisha is there for Gujarat.
So she'll be appearing for Gujarat.
So after you, Mr. Datar will argue. I think substantially learned solicitor has covered a lot of canvas.
Yes,
so
yes,
we
yes.
can.
So I
Therefore,
think
if just short 1-page
I
note,
won't be
which would
repeating,
just
but
like
wherever additions.
this really helped, because it just brought focus on the whole thing.
A little more than that.
All right. So we resume on Wednesday. Thank you. By the way, have a look at the 242nd report of the Law Commission. Learned Attorney was a member of the 242nd. There was a report on the matrimonial alliances, freedom of matrimonial alliances. Attorney, am I right that you were a member of the Law Commission then?
Yes, I've seen that. I was a member.
And Annexure 1 is the bill which you had prepared for freedom of. There's no estoppel against the attorney, but it was very interesting. अच्छा लिखा है वो रिपोर्ट में अभी मंगा